Delivery of order, item number 1.
For reasons mentioned in the order, the prayer for bail is rejected. Yes.
Yeah, please. On Monday, I have filed a criminal petition against my lord non-bailable warrant. May I pray on it is in between vacation fixed in the court. I am paying a direction on tomorrow, my lord, motion.
Okay.
I am like.
May I please, your lordship? With the consent of other side, lordship, I beg to mention item number 60. Here, lordship, he not is appearing, lordship, he is not well, lordship. Let it be come up on 16th, lordship.
Heard Mr. A.K. Gupta, learned
Lordship,
counsel.
I'm SS Roy for the respondent.
Item number 60.
Yes, your lord.
Heard Mr. S.S. Roy, learned counsel for the petition.
Respondent.
Who prays for an adjournment on the ground of personal difficulty.
Lordship, here in this case, senior government advocate is appearing, he is unwell, lordship.
On the ground of personal difficulty of the conducting senior government counsel. He submits that he has informed learned counsel for the petitioner regarding his prayer for the adjournment, who has no objection to the same, and same is allowed. Let this matter be listed after Puja vacation on a date to be fixed by the judge.
Lordship, let it be on 16 because CD is called here, lordship. We will returning the CD today. Then
Oh, okay. Let this matter be listed on 16th of October.
I am for the petition.
May please, your lord.
Also, show the name of Mr. A.K. Gupta.
His name is. Okay.
May please, your lord. A criminal revision petition against the my lord conviction, my lord. It was expired on 15/9 and we have filed on 15/9 petition. The revision is not yet, my lord, listed. Well, tomorrow may be taken, my lord.
Okay. But tomorrow, motion item.
Motion item.
Okay.
May I please? I beg to mention for listing a criminal petition, my lord, against my lord petitioner's warrant over.
When is the date?
My lord, in the month of October, that is is not.
After Puja vacation.
May I please, your lordship, I beg to mention for listing one bail application for tomorrow, lordship. Motion is stage, lordship.
Okay.
Deeply over.
Beg to mention for listing of a bail application.
When have you filed?
Yesterday. Two bail applications. Also, what happened in these both?
Tomorrow. Tomorrow.
Similar prayer, my lord, for listing.
When have you filed?
Yesterday, my lord. Motion matter.
Tomorrow.
Tomorrow. Same.
What is the matter?
Better, my lord,
Bail application. Tomorrow. More.
May it please, your lordship. My lord, what happened, my lord, today a matter was listed in court number 25, my lord. But now it has been,
What is the matter?
my lord, on a POCSO matter, a father is inside, my lord. There is no whisper against the father, my lord. It was listed on 23rd, 23rd, it was a holiday. So it was listed today. Today also, my lord, it was, my lord, the honorable court is not sitting, my lord.
Tomorrow.
Tomorrow, along with, my lord, mother's bail application is also there.
After Puja vacation.
No, my lord. But no, mother is fixed tomorrow.
Okay.
But father was fixed today.
Tomorrow.
To tomorrow, my lord.
Similar prayer for item number 45, before court number 25.
What is the matter?
Lordship, relating to.
The listing is subject to the risk that
32
if the
days.
matter does not reach us,
Yes, Lordship.
these will be
32
shown
days
as
is custody,
leftover.
Lordship. 7 years, Lordship.
What is the matter?
Relating to seizure of some oil, Lordship.
After Puja vacation.
Lordship.
After Puja vacation.
32 days. Lordship.
After Puja vacation.
Please, your lordship. I beg to mention for listing of a AB for tomorrow, your lordship.
When have you filed?
Yesterday.
Okay.
Much obliged.
Make it, Lordship. I'm trying to list a criminal petition for motion matter tomorrow, madam.
Well, bail application.
A criminal petition for motion matter
Okay.
tomorrow, madam.
Okay.
Much obliged.
May it please, your lordship, I beg to mention item number 41, lordship. 41, lordship.
Yes.
Password for the day, lordship. After vacation, lordship.
What is your name?
M. Mondal, lordship.
Heard Mr. M. Mandal, learned counsel for the petitioner who prays for an adjournment. The prayer is allowed.
We have not visited the city also, madam.
Let this
Please, Your Lordship, I beg to mention.
let
item
this matter be
7.
listed on 24th of October for case diary.
Lordship, I beg to mention item number 7. The matter may be kindly passed over for today.
On request of Miss, what is your name?
A Basu.
A Basu, learned counsel for the petitioner. The matter is adjourned for the day.
May I please, Your Lordship?
Yes,
I beg to mention a bail application which was filed today. It may be taken on tomorrow.
no. Let the registry decide.
Lordship, petitioner has been behind the hour for more than.
No,
6
you have
months.
filed. If
I
it,
have actually filed Monday, but section given number today. So I beg to I have mentioned today I have filed.
okay,
May I please, Your Lordship? May I please, Your Lordship? I beg to mention for listing of a criminal revision petition I filed on last Monday, Lordship, maybe for tomorrow.
okay.
May I please, Lordship?
I may allow to withdraw a bail application.
Tomorrow.
Lordship, another way is, Lordship, item number 26, Lordship.
Yes,
Lordship, yeah, this item also I may allow to withdraw, and this case, there is some technical error, Lordship. I may allow to revert to file a fresh one.
heard me,
26,
heard Mr.
yeah, long.
A. Alam, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition on the ground that some error has crept in the petition, with liberty to file an appropriate application. The prayer is allowed with liberty sought for.
Lordship, I beg to mention for listing the application on tomorrow,
When have you filed?
22nd of September.
For motion? Okay,
May I please, I beg to mention for listing for motion lot, AV. We have filed on 22 evening, yesterday morning it was numbered,
okay.
obliged. My lord, I beg to mention for listing, my lord, motion matter.
When have you filed?
One is on 22nd and one is yesterday.
Okay.
Much obliged.
May I please? Lordship, I beg to mention for listing, Lordship, anticipatory bail application. Yesterday I have filed.
Okay,
Deeply of course.
May it please the lordship, I beg to mention for listing on motion BA, I filed on 19.
okay.
It is today also listed, but honorable court is
Tomorrow.
fine.
May it please the Lordship. Lordship, with the consent of the other side, beg to mention item 53 of today's list.
Heard Ms. P. Barua, learned counsel for the
Petitioner.
petitioner, who prays for an adjournment. She submits that she has informed the learned standing counsel CBI regarding her prayer for adjournment. The prayer is allowed. Let the matter be listed after puja vacation on a date to be fixed by registry.
Deeply obliged.
I beg to mention for listing of a criminal appeal, Your Lordship, for tomorrow.
Criminal appeal after puja vacation.
There is some urgency in the matter, Your Lordship.
What urgency?
But Lordship, the person is behind bars, Your Lordship.
After puja vacation.
May please, Your Lordship. Lordship, I beg to mention for listing of bail application, Your Lordship, for motion.
Tomorrow.
Oblige, Your
I beg to mention item number 27 of daily list after puja devotion.
27.
Then,
Heard Mr.
MS.
MS Ali, learned counsel for the petitioner, who prays for an adjournment. No personal difficulty. Prayer is allowed. Let this matter be listed after puja vacation.
May I please, Lord? I beg to pray for listing of a criminal revision petition tomorrow. my lord.
What is the
Motion, my lord.
matter? What is the matter?
My lord, there is the order of demolition within 7 days, my lord. The order under challenge of 29, my lord. During the situation, my lord, due to the situation in Assam, my lord, we got the impugn order only yesterday, my lord. We are filing today, my lord, tomorrow.
Okay.
I'm obliged.
May I please, that's why I beg to mention for listing of BA, file on yesterday.
Okay.
May I please, Lordship? For listing of the matter, Lordship, the listed before the Honorable 25 court, for item 2, Lordship. Tomorrow, Lordship. Listed before the Honorable court.
Motion.
25, Lordship.
Motion item.
Motion matter, Lordship.
Okay.
Earlier 2 occasions listed but not discussed.
Motion.
So moved.
Okay.
Item 2, court number 25, Lordship.
May I please, Your Lordship, I have
We can mention item number 58 of supplementary list. Or single. 58.
What is your prayer? What is your prayer?
Lordship, TCR is come, need a hearing, Lordship. And
You are seeking adjournment. What is your name?
Mr. S. Fazil.
Heard Mr. S. Fazil,
Mr.
learned counsel for the petitioner, who prays for an adjournment. The prayer is allowed. Let this matter be listed after puja vacation. Yes,
May plead your lordship. No, I beg to mention for listing the bail application of motion matter
tomorrow.
tomorrow.
Yes, my prayer for listing AB matter for tomorrow. I have filed in on 22nd, last Monday. tomorrow.
Okay.
Congratulations.
Similar prayer, my lord, for tomorrow, my lord. Regular payment.
Okay.
May please your lordship. Lord, I beg to mention item 40 of 25 courts list, my lord. So bail hearing matter, my lord,
Bail hearing immediately after puja vacation.
I am behind the bar since 30th of August. my lord.
All are behind the bars.
Can it be, if your lordship permits, can it be accommodated tomorrow, my lord, if time permits at all?
No court will be able to finish the list if we fix. Let it be after puja vacation, immediately after puja vacation.
Please, your lordship, I beg to mention listing of it, in bail application for tomorrow,
When have you filed?
yesterday.
Okay.
But please, I beg to mention for listing my lord, for motion my lord.
What matter?
PA matter, bail application.
Okay.
Kindly tomorrow, my lord.
Yes, allowed.
Immediate, your lordship, motion matter, tomorrow, your lordship, yesterday I filed.
Okay.
I beg to mention for listing motion.
Listing of,
AB,
when have you filed?
yesterday morning. Yesterday morning.
Okay.
Tomorrow also.
May please your lordship, item number 21. My senior is unable to appear as he is engaged before another matter before Luxembourg Session Court,
What is your
which
name?
was fixed earlier.
On request of learned counsel for the petitioner,
Lordship,
this
Since
matter
the
is
first-
adjourned.
since the corresponding trial court matter is fixed on 17/10/2025, I most humbly pray that this matter may kindly be taken up on any convenient date before 17/10/2025.
On request of learned counsel for the petitioner, this matter is adjourned. Let this be listed on 16/10.
May please, your lordship. Lord, I have praying for listing of a matter, my lord, the motion matter tomorrow, my
What matter?
lord, the anticipatory bail, my.
Okay.
May I please, your lordship, lordship, prayer for listing of a criminal revision petition and another 2 bail application.
Criminal revision petition after puja vacation.
Lordship, there is a IA, the petitioner is behind the bar, it is an NIAC matter. So it may be listed tomorrow, your lordship.
Tomorrow,
It has been, the matter has been settled between both the parties. The conviction has already been made, so he's behind the bar.
okay.
Tomorrow, your lordship. All right.
May please, Lordship, they can mention for criminal petition, Lordship, quashing on a FIR, Lordship. We are from Kolkata, but the police is constantly harassing, Lordship. Police is constantly calling us also. Can it be listed tomorrow? It's totally a civil dispute, Lordship.
No.
42406, Lordship.
No. After puja vacation.
May please, your lordship. My lord, I beg to mention item number 51, my lord, in court number 25.
What is-
My lord, it was just court petition, the accused petition, my lord. Already 2 accused petitions were released by the honorable court, my lord.
What is the matter?
304 part 2, my lord, 7 years imprisonment. As per Kiran Kumar judgment, my lord,
Immediately after puja vacation.
the present petitioner is a diagnosis person, my lord. He's a diagnosis person, my lord. Because since the process of judgment, my lord, he was hospitalized, my lord. So Lord, kindly, it can be accorded tomorrow, my lord. Lordship granted bail to 2 accused persons in last.
Your lordship granted bail in this time of there, my lord. Your lordship last of.
Okay, okay, tomorrow.
Give them.
Lordship, I beg to mention item number 6 of the daily list, lordship, I may be allowed to withdraw this lordship.
Heard Miss P. Sharma, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw this instant anticipatory bail application. Prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Matter.
May I please your lordship, I beg to mention a listing a I lordship. This is filed
In what matter?
criminal revision petition lordship.
After puja vacation.
The urgency is that he is behind the bar since December.
After
2020.
puja vacation.
May I please, your lordship. Lordship, I have filed this, I have mentioned this matter yesterday also, lordship, because the lordship has directed me to approach the registry, and I have approached the registry, lordship. Everything is there. Lordship.
What is the matter?
Lordship, my stay was vacated, and then in the family court, lordship, the matter is fixed tomorrow.
What is the matter?
Lordship, it is about a petition, lordship, that has been rejected by the court with regard to calling of a witness, lordship. Now, the case is at the stage of arguments, lordship, and tomorrow the case is fixed, lordship. Now, my stay was vacated because my name was not shown.
After puja vacation.
If tomorrow, because
No, after puja vacation.
Lordship, I beg to mention for listing of a regular bail application for withdrawal purpose for tomorrow, lordship.
Okay.
Okay.
May I please, your lordship. Lordship, one case, judgment of a DV case, lordship, had been challenged by way of criminal petition, which has already been filed, lordship. And lordship, in that case, lordship, already restrains warrant of arrest.
After
was-
puja vacation.
Lordship, but the matter is fixed today, tomorrow, lordship.
After puja vacation.
Much obliged.
May I please, your lordship, lordship, I beg to mention for listing of a bail application. Just filed out yesterday, lordship. For
Motion.
tomorrow, lordship.
Okay.
Motion matter, lordship.
Okay.
Next.
May I please, Madam, I pray for listing of one criminal appeal against conviction. It was last listed on Monday.
After puja vacation.
My lord, here the date is fixed on 26. Tomorrow is for appearance for serve of the sentence. He is on previous bail till tomorrow, my lord. It was last listed on Monday, my lord, but due to paucity of time could not be taken up, my lord.
Okay, tomorrow.
May I please, your lordship. Lordship, I beg to mention item number 3 for adjournment.
Heard Mr.
M. Rahman on behalf of.
M. Rahman, learned counsel for the petitioner, who prays for an adjournment. The prayer is allowed.
Another mention for listing, lordship, to AB, lordship.
When have you filed?
Yesterday.
Tomorrow.
May it please your lordship. Lordship, I beg to mention for criminal revision petition which was filed on 18/9, lordship, but till date not yet listed, lordship. The petitioner is on previous bail, lordship. 18/9 I have filed, lordship. Criminal revision petition.
What is the urgency?
Lordship, he is on previous bail till 12th of October, lordship.
Till 12th of October.
Lordship,
Okay, tomorrow.
oblige your lordship.
May I please, your lordship. I beg to mention for listing of AB, lordship.
Tomorrow.
Lordship, I beg to mention for listing one regular bail application tomorrow, madam.
Tomorrow.
Obliged.
May I please, your lordship? I am praying for listing for tomorrow, bail application for
Okay.
motion.
Okay,
And for withdrawal.
tomorrow. Or you want it today? Okay, today at 2 p.m.
May I please, your lord. Lordship, beg to mention item number 18 and 19, lordship. Both the matters may be passed over for the day, lordship.
Heard Mr.
Amen.
A. Mena, learned counsel for the petitioner,
18 and
who
19.
prays for an adjournment on the ground of personal difficulty. The prayer is allowed.
May it please, your lordship. Beg to mention for listing, my lord, tomorrow.
What?
Criminal petition, my lord. It was last directed to be listed this week, but I have approved the registry, but they have. asked me to-
Immediately after puja vacation.
My lord, tomorrow, if you can,
No, it may not be possible. Immediately after puja vacation.
oblige.
Chief, I beg to mention item number 26 from DLO code number 25.
What is your prayer?
Chief, records are already there. If possible, can be taken up by tomorrow.
No,
It is received.
immediately after puja vacation.
Lordship, the thing is that the
You
allegation-
mentioned before the court tomorrow,
this court,
the court in which the matter may be listed.
May it please, your lordship, but I beg to mention item number 50 of court number 25. madam. Court number 25. It's an IA, my lord, for suspension of sentence, my lord. Can it be taken up today, my lord?
No, immediately after Puja vacation.
My lord, similar prayer with regard to same court. with regard
Similar
to-
order,
Similar,
immediately after Puja vacation.
the item number, the item number,
You give a mention memo.
mention them.
I just mentioned, madam, my lord, item number 13, 22, and 23 of court number 25. All are military connected matters, my lord. This matter may be made listed on 13 of October.
No, registry will automatically list it on some other day. No need for mention.
My lord, I beg to mention one item of item code number 25, my lord. It was listed as item number 31. My lord may be taken up, my lord, because my lord, the petitioner is in jail. And the charge sheet has been laid, my lord. So it may be disposed of, my lord, because the vacation is ahead. My lord, kindly take up this matter.
Okay,
Item 31 of 20. Yes, my lord.
you give a mention memo.
Yes, lord. All right.
Your lordship, item number 39, the case diary has not yet been received, your lordship. Number
39,
39.
heard Mr. K.K. Parashar, learned,
Here,
heard Mr. G.R. Datta, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for
my lord, charge sheet
production,
submitted.
who submits that charge sheet has been laid in this case, bearing charge sheet number
114/2025, dated 25/8/25.
in view of this fact that charge sheet has been laid in this case. This bail application is disposed of with an observation that the petitioner may approach the trial court
Your lordship,
and may pray for regular bail before the said court.
your lordship, I just have to check one thing, if it has been filed after 180 days, because as per the NDPS.
You
Act-
check, I have passed order, do whatever you want to do.
Your lordship, if it may come in due course, if the normal.
It
course
is disposed of. Yes,
Please, your lordship. Lord, I am seeking your lordship indulgence, my lord. Unusual prayer, my lord. My lord, I am paying for listing of a anticipatory bail unlisted today, my lord. But difficult.
today it is not possible.
But I have been called before the division bench of Itanagar bench for tomorrow of a matter, my lord. I have to move tonight. I had requested the registry yesterday, my lord.
No, today it may not be possible.
Lord, if your lordship can permit, my lord, we can take a chance, my lord, in that case. Some, if time permits, my lords. There is some urgency, my lord. So small children and my lord, ladies are there, my lord, in this case.
Okay.
This is the matter on the other day, we raised the issue of 47 and 48 PNS.
But why it has come in motion?
Additional.
My lord, let's come on motion, charge sheet submitted.
We have already.
Charge sheet submitted. You pray before the trial court.
Raised the issue of 47.
You can raise this plea before the trial court also, when the charge sheet has been laid. Yes,
CS
Mr.
number 214/25.
Nawaz, you want to say something?
47 lordship could have non-compliance on that part, lordship. Mainly on the legal point, lordship. I am not on the merit of the case.
No, but
lordship.
we don't have any material.
Okay, my lord.
We,
47, I have given the copies, lordship, on the other day also, lordship. I have given the actual affidavit also.
you take this plea before the trial court.
Lordship.
Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. S. Nawaz, learned additional public,
Okay,
S. K.K. Parashar, learned additional public prosecutor, as well as Mr. S. Nawaz, learned counsel for the respondent number 2. Learned additional public prosecutor submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid. The
CS number 214.
bearing charge sheet number
214/25, dated 23/9/25.
in view of the fact that the charge sheet has been laid, the petitioner may approach the regular court and may approach the trial court and may file a application for regular bail before the said court, if so advised.
Item 4.
My lord, in this case, my lord, CD may be called for along with my lord FSL.
Heard Mr.
AFC.
A. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, call for the case diary.
Along with my lord FSL report.
It will be,
NDPS, my lord.
no, we cannot force. If FSL report is collected, it will be there in the case diary.
My lord, wait me.
Let this matter be listed on 28th October.
May be the lordship. Lordship may kindly come to the FI, madam, that is 15th. Madam, the sections which are on, they has been registered are 61 to 351 to 79, read with section 67 of the IT Act. But all these sections are available sections, madam.
All sections are available, then
ma'am.
why the trial court
Yes, ma'am, that
rejected?
is the question, madam. Now, since there is an amendment in the IT Act, since section 67 has been incorporated. Earlier, the punishment was 5 years for the first instance. Now, madam, it is 3 years, madam. And which is available, madam.
Read section 67.
Punishment for publishing and transmitting options materials in electronic form. Whoever publish or transmit or causes to be published or transmit in the electronic form any material which is lascivious or appeals to the Puritan interest, or if its effect such as to tend the
IT Act, sir.
and corrupt person
IT Act. Yes,
who are likely having regards to all relevant circumstances to read, see or hear the matter contents or embodied in it shall be punished for first conviction with imprisonment of either description for which it may extend to 3 years, or with fine, which may extend to 5 lakhs rupees, and in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 5 years, and also with fine which may extend to that 10 lakhs rupees.
why it is available?
But it is because it is which may extend to 3 years.
So why it is available if it is 3 years?
And my section 77B
Of
of the IT Act, madam. 77B. Offenses with 3 years imprisonment to be available.
okay. And others, section 60,
Others available, madam. Others are available, madam.
then why the trial court rejected it?
Yes, madam. Both the courts, madam, below.
You took this plea before the said court.
So, madam, don't think so, madam. They are not aware of this new amendment, madam.
Heard. Mr. S.P. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Sanat Chaudhary, who has been detained behind the bars since 30/8/2025 in connection with Dhubdara PS case number 43/2025 under section 61 within bracket 2/351 within bracket 2/79 of BNS, read with section 67 of the Information Technology Act. Stop. Learned counsel for the petitioner has submitted that the offense under which this case has been registered are bailable. However, the court of, where is the rejection order?
My lord, the first case, my lord,
Which court rejected?
the judicial magistrate first class, my page number, my lord, 22.
However, the Court of Learned Judicial Magistrate First Class Golpara, while rejecting the application for bail by its order dated 1/9/2025, passed in Dubdara PS case number 43 of 2025, has ignored the said provision, ignored the said fact. Learned counsel for the petitioner has submitted that the offense under section 67 of the IT Act is punishable with imprisonment which may extend to 3 years for the offense committed for the first time. He also submits that as per section 77B of the Information Technology Act, 2000, all the offences under the said act where prescribed punishment is up to 3 years are to be bailable. Stop. Learned counsel for the petitioner has further submits that the other offences under Indian Penal Code which are involved in this case are also bailable. Stop. Learned additional public prosecutor has also fairly submitted that the offences involved in this case are bailable. Stop. In view of the fact that this case has been registered under bailable offence, the petitioner has the right to go on bail. Accordingly, he is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Ilaka magistrate with following conditions, number 1 and number 2. This bail application is accordingly disposed of.
May I please, Your Lordship? My lord, the petitioner is paying for pre-arrest bail against the PRC case, my lord.
PRC case,
PRC case, my lord, charge sheet has already filed, and the name of the petitioner is not mentioned in the charge sheet. But my lord, the
your name is not mentioned.
not my
Then-
lord, in the charge sheet. And my lord, the summons was issued to Babu Sheikh or served to the petitioner. Petitioner is a Babu Sheikh. Kindly see the my lord summons.
No, you go to the court and say, you don't accept the summons.
Maybe my lord,
No.
demanded by the trial court.
No, you need not to appear before the court if you are not Babu Sheikh. If you are not the said person,
My lord.
how you can be granted bail, anticipatory bail in
Only
this?
the summons was served to the petitioner, my lord.
You ignore the summon if you are not that person.
We may not accept this summon, my lord.
Or you may clarify to the court that someone has been wrongly served on you. Heard, Mr. M. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Bablu Sheikh. Father's name is same,
Same, my lord. Father's name is same. Then
Bablu Sheikh, who is apprehending his arrest in connection with PRC case number 64/2025 under section 365 of the Indian Penal Code read with section 25(1) within bracket 1 within bracket A within bracket B of the Arms Act pending before the Court of London, Judicial Magistrate First Class, South Salmara. Learned Counsel for the petitioner has submitted that the petitioner's name is Bablu Sheikh, whereas the charge sheet in the aforesaid PRC case has been filed against one Babu Sheikh. He further submits that, where is the summons?
Someone, my lord, page, my lord, 13, my lord.
He further submits that the summons issued by the trial court in the name of Babu Sheikh has been wrongly served on the petitioner, and therefore he is apprehending that he may be arrested. Stop. On the other hand, learned additional public prosecutor submits that there is no apprehension of getting arrested, of the petitioner getting arrested, as the petitioner has only been served with the summons, that too in the name of some other person. I have considered the submissions made by learned counsel for the petitioner, learned counsel for both sides, and have gone through the materials available on record. The apprehension of the petitioner that he may be arrested in connection with the aforesaid PRC case has no basis, even if the summons issued by the trial court in the name of Babu Sheikh is wrongly served on the petitioner. He may appear before the said court and may clarify the fact before the trial court. In any view of the matter, there is no apprehension of getting arrested, apprehension of the petitioner getting arrested. Therefore, this anticipatory bail application is dismissed with above observations.
And maybe dispose of state of dismissal.
Disposed of with above observations.
Highly obliged, your lordship.
But in this case, your worship may remembering, FIR was, kindly see your worship on page 29. Earlier we got interim order, we have gone there, my lord, ultimately came to know that another case is yet to be registered, but they are not registering the case, my lord. One day you want some information whether any case is registered or not, my. Page 30, your worship.
Now also it is not registered.
Not yet till to divide.
Then why have you?
Waiting for me, once I go there, that, my lord, this is the.
So same order will be passed.
No, my question, my lord, same order means whether any case is registered or not, let them bring in information, my lord.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, learned senior counsel, learned senior advocate, assisted by Mr. J.M. Suleiman, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned senior counsel for the petitioner submits that this application under section 482 of BNSS has been filed by the petitioner on the basis of reasonable apprehension that he may be arrested by the police of Badarpur police station.
Other than Malat 149, one case is there. Badarpur case number 149, 25 is there.
Yes, in case you got interim.
In connection with
Other than 149.
some other case, then Badarpur PS case number 149/2025, in which the petitioner is already on interim bail. As the petitioner is unable to inform this court regarding the pendency of any other case apart from Badarpur PS case number 149/25. 149/25. Let a report be called for from the officer in charge of Badarpur Police Station as to whether any case is pending apart from Badarpur PS case number 149/2025 against the present petitioner, above named petitioner in the said police station. Let the report be.
I don't let them by telephone.
Huh?
They may bring the information. Court it tomorrow is the last court. One day telephone instruction will do, my lord.
Otherwise, your apprehension does not have any basis.
Yes, my lord, it is there, my lord.
So,
I made a credible statement also, my lord. That I came to know reliably that it is filed at the instance of the informant, my lord.
okay, bring learned additional public prosecutor is requested to get the said information from the officer in charge of Badarpur Police Station over telephone. Let the matter be listed again tomorrow, that is on 26/9/2020.
Maybe. Feeding, I think also.
Heard Mr. A. Mundal, learned counsel for the petitioner. Also heard Mr. K. Parashar. Let the case diary be called for. Let this matter be listed 23rd October. Yes.
482 application lordship. FI is page number 13.
It is required, 21B NDPS.
What is-
Lordship, though 21B, your lordship. The FI, his FI is against a lady, your lordship. Against a lady who has been arrested, and from where these contraband were seized, your lord. And she is already in bail, your lord. She's already
Who are you?
I am a local person of that locality. From
Why
where
are you apprehending arrest?
the police is very frequently visiting my house, your lord.
There must be some material.
Nothing also, nothing. I am nowhere connected, no in the FIR, nothing. The main is from where these contrabands were seized, specifically mentioned in the FIR. She has been granted bail. And I have been searched frequently visited by the police officer in charge of me. Till the CD comes, I may be protected. There is nothing in the FIR against.
No notice was given, how.
No, what is the basis? When police visited you?
Frequently at various times.
Where is the statement? Where is the statement?
Page number 3 onwards.
No, where is the para? Where?
Page number 3, page number 7.
When police visited?
They on various dates, your lordship.
No, you have not mentioned even a single date.
Yes, the date is not.
So this is not enough. If police has visited, if you know that, you have to mention why are you suppressing the facts from the court?
Not suppressing, your lordship.
Then why you haven't mentioned the dates?
I should have mentioned, your lordship, but they
Case
have not
diary.
mentioned the specific dates, your lordship.
Case diary. Heard Mr. R. Chetri, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary. Let this matter be listed again on 27th October.
Okay.
May it please, your lordship. Lordship, page 12 is the FIR. My lord, here FIR reveals that, my lord, the informant says that while
daughter was going to school, the accused petitioner restrained her on the road and tried to rape her, took some photo snaps and viral it, my lord. But my lord, FIR, my lord says nothing, my lord, from which mobile, my lord, it is viral, nothing is there. So my lord, in fact, my lord, there was a love affair because the victim girl is 16 years, accused petitioner is 18 years, my lord. So they are tender age, my lord. So there was love affair. When the father come to know, my lord, the father has loved the affair. No, nothing, my lord, from which mobile, my lord. Could be there, my lord.
Mobile,
So
every
yes, my
lay
lord.
person, cannot.
Heard Mr. M.R. Khandekar,
But
learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Considering the nature of offense involved in this case, as well as nature of accusation made in the FIR, perusal of the case diary would be necessary. Hence, call for the same. Also issued notice to the respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 30 October.
Till then,
No, offense is
my lord will see, my lord, 64, nothing will come. On road, my lord, while she was going, tried to rape. This is, my lord, visible on the day, my lord.
but accusation is there. So,
Other-
date agadiyo.
I have another thing, my
23rd
23rd.
October.
15, my lord.
Okay, 15 October.
13.
May I please your lordship, for 82 lordship bail application under section 75(1), 78(1), 35 of BNS and section 12 of POCSO lordship. And the next is at page 13 lordship.
Case diary would be required.
Lordship, my humble submission, lordship, the accused petitioners and the lordship informant, they both are residing in the same house, lordship, same rented house. Lordship, may kindly consider their address, lordship, house number 8, Byland 5, Madhav Path, Forest Gate, Hengrabari, Guwahati. And my lord, place of occurrence and time of occurrence, lordship. Place of occurrence is, lordship, in front of lordship DC office, the district commissioner's office, Hengrabari, and Amrit Udyan, lordship.
No. With the accusation requires perusal of the case diary.
Lordship, petitioner number 1, lordship, he is a married person. He has, lordship, 1 and lordship, half-year-old child, lordship, and both the petitioners are, lordship, brothers, lordship, own brothers, lordship. And lordship, in such a busy place and in such broad daylight, lordship, such type of occurrence is, lordship, practically, lordship, not possible. So my lordship, humble submission, lordship. And there was an altercation between the petitioner and the lordship informant, lordship, regarding their accommodation in the rented house, lordship. And this is the outcome of the lordship, this FIR is the outcome of that, lordship, only.
We'll fix short date.
Lordship, till then, lordship, I may be lordship,
Heard
contacted.
Miss R. Gogoi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Considering the nature of accusation leveled against the petitioners in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary.
15.
Also issue notice to the respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 15th of October, list accordingly.
From supplementary.
Lordship, ma'am, interim protection.
May please your lordship. Lordship, your lordship, allegation under POCSO Act and Prohibition of Child Marriage Act, Your Lordship. This is a politically motivated case, Your Lordship. The petitioner herein is an elected ward member. The informant, one of the informant is also an elected ward member. This FIR has been, this was not also an FIR filed before the OC, but it was a kind of memorandum filed before the SP, Your Lordship will find. It is on page 13. May I read out, Your Lordship, the translated copy, Your
Now, what is the accusation?
Your Lordship, that my wife, when I married her, she was a minor. But I have annexed documents here to prove that she was above 18 years old. Her birth certificate, her Aadhaar card suggests, the marriage certificate suggests, and my daughter was born when she was 20 years old. It was just filed just to prevent me from attending the meeting, which would
Yes.
elect the president, Your Lordship. Which would elect the president, Your Lordship.
You have, when your marriage was,
Your Lordship will find the marriage.
the date of marriage,
Marriage registration certificate will find on page 21,
what is the date of marriage?
39/2008.
What is the date of birth of your wife?
Birth certificate and the Aadhaar card certificate suggests that my wife was born on 2/1/1990. And I've also annexed the birth certificate of my daughter.
Heard Mr. I. Hussain, learned counsel for the petitioner. This application under section 482 of BNSS has been filed by the petitioner, namely Burhan Ali, who is apprehending his arrest in connection with Kutia Police Station case number 94/2025 under section 336 within bracket 3 of BNS 2023, read with section 6 of the POCSO Act. Read with section 6 of the POCSO Act and section 9/11 of the Prohibition of Child Marriage Act. Where is the FIR?
Your Lordship will find the FIR on page, it starts from page 13, the translated copy.
The gist of accusation in this case is that one, Jiarul Islam had lodged an FIR.
Your Lordship, they are two informant, Jiarul and Diganta Saikia.
Jiarul Islam and one Diganta Saikia had lodged an FIR on 11/9/2025 before the Superintendent of Police, Vishwanath District, inter alia, alleging that the petitioner had married had performed a child marriage, as at the time of his marriage, the age of his wife was less than 18 years. How many children do you have?
One daughter.
How old she is?
She was born in 2010. I have annexed her birth certificate to Your Lordship.
2010. Now she is 15 years old.
Yes, sir.
My lord, at the time of marriage, my lord, as per the birth certificate, she is 18 years, 8 months.
Okay.
Your Lordship, the FIR itself suggests that
Learned counsel. No, clearly. At the time of marriage, the date of last line to perform. 18 years of age. Stop. Learned counsel for the petitioner has submitted that the FIR against him has been lodged only to harass him by his political rivals. He submits that he had married his wife about on 13/9/2008, and on the date of marriage, his wife was
29, 2008.
20 or 30.
30.
20. I got it. 28th of September. my lord.
okay. Your Lordship, it is a
On 28th of September
September.
2008, and on the date of marriage, his
Lord,
wife was more than 18 years of age. more than 18 years of age. In support of his submission, he has furnished a copy of birth certificate as well as marriage registration certificate. He further submits that out of the said wedlock, the petitioner has a daughter who is presently 15 years of age. Stop. Learned, on the other hand, learned additional public prosecutor also submits that on perusal of the birth certificate, it appears that the date of birth of the where is the birth certificate?
But you will find on page 19, your lordship. Date of birth 2/1/1990.
Date of birth of the
2/1/1990.
victim is 2/1 1919
90.
90.
1919 1990
90, yes.
90.
11 side, my lord. Third line.
Firoza Khatun,
Aadhaar
Aadhaar
number, then date of birth.
2/1 1990 2/1 1990. Stop. Thus, it appears from the perusal of date of birth certificate that the petitioner is that the wife of the petitioner was of the age of majority when when her marriage was performed with the petitioner. Considering the above fact, this anticipatory bail application is disposed of without issuing notice to the respondent number 2 with a direction to the petitioner to appear before the investigating officer of Sutia Police Station case number 94/2025 and cooperate in the investigation. If within 7 days from the date of this order, if he does so, in the event of his arrest in connection with the aforesaid case, the petitioner, above named petitioner, shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1 and 2. This anticipatory bail application is accordingly disposed of.
Item 14.
My lord, I have filed this petition, agreed with an order allowing interim maintenance of ₹7,000 in favor of the opposite party, my lord.
7,000.
Yes. That the petitioner earned only 17,000, my lord. Out of 17,000, for paying 7,000 is difficult for the petitioner.
What is the date of the interim order?
My lord, order dated 3rd of June 25. At page, my lord, 199 of my petition.
We are issuing notice.
My lord, in the meantime, order may be stayed, my lord.
No. Heard. Mr.
I'm sorry, my lord.
N. Learned Counsel for the petitioner. This application under section 442 of BNSS has been filed by the petitioner, impugning the on order dated 3/6/2025 passed in FC within bracket criminal number 412/2024 by the which court has passed
My lord, Family Court 3 Kamrup Guwahati.
by the Court of Learned Principal Judge, Family Court number 3 Kamrup Metro, whereby an interim maintenance of ₹7,000 was directed to be paid by the petitioner to his wife, who is the respondent in this case. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
My lord, interim order may be considered on the retirement.
The prayer for interim relief may be considered after due service of notice on the respondent.
Obliged, your lordship.
May I please your lordship? Lordship, this is a petition file for quashing, my lordship. This is with regard to the maintenance, my lordship. The petitioners now are the stepsons, my lordship, are the stepsons of the respondent, my lordship. During the lifetime of the father of the petitioner, father of the petitioners, he got married 3 times. Petitioner number 1, 2, 3 are the sons of the first wife. The mother is alive. Petitioner number 4 is the son of the second wife. The mother is alive, my lordship. And petitioner and my lordship, the respondent, after the death of the father of the petitioners, my lordship, after taking part share of the property along with the cash, along with the maintenance for the daughters, which are also admitted by the evidences, my lordship. I have annexed all the PWs. And
What is the stage of the?
8,000 is granted to the respondent, for which 4,000 for the respondent and another 4,000 for the daughters of the respondent, my lordship. My lordship,
We will admit,
my lordship,
will issue notice.
my lordship, but lordship, here I pray for an interim, my lordship. The reason why I'm praying is that, my lordship, the evidences, even the respondent has admitted, my lordship.
We'll examine that.
Lordship, but at this stage, my lordship may consider this.
What is the urgency?
Because, lordship,
You are unable to pay.
lordship, we all live in the PPL category. I have my petitioner number 1 has his wife, 2 minor children, and the mother. Petitioner.
Whether any execution case has been filed,
It's not filed, but my
then
lordship.
there is no urgency. No.
My lordship may kindly consider this is not my lordship.
No. Heard Miss S.G. Barua, learned counsel for the petitioners. This application under section 528 of BNS has been, no, sorry. This application under section 438/442 of BNSS has been filed by the petitioners, namely 1, 2, 3, 4, Nam Yarkra Likhibo, impugning the order dated 13/6/2025 passed by the Court of London, Subdivisional Judicial Magistrate S. Lakhimpur in Miss Case number 44/2022, whereby a maintenance allowance of rupees 8,000 per month was directed to be paid by the petitioners to the respondent and
And her 2 daughters.
her 2 daughters. Issue notice to the respondent.
My lordship,
The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
my lordship, will be pleased to peruse the evidence of the respondent.
No,
My
we at this stage we will not go into those. Let the respondent appear. The prayer for interim relief may be considered after due service of notice on the respondent.
Can there be that I have submitted that no execution cases filed here today, my lordship, can that submission will be there?
Yes. The prayer for, as presently no execution case has been, as learned counsel, as learned counsel for the petitioner has submitted that till date no execution case has been filed in respect of the grant of maintenance by the petitioner. The prayer for interim relief shall be considered only after due service of notice on the respondent.
Oblige, my lordship.
Item 16.
Wait, Lordship. Well, it is the second round of litigations regarding interim compensations which has been prescribed under 143A. At this stage, I just want to issue a notice to the opposite parties.
Okay.
Nothing more than that.
Heard Mr. P. Bora, learned counsel for the petition. Learned senior counsel, assisted by Mr. H.K. Sharma, learned counsel for the petitioner. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Oblige,
Item 17.
May I please, Lordship. This revision is filed against maintenance, my lord. I am put order case number 54, my lord.
Who is the respondent?
Respondent is my wife, my lord.
How much is the maintenance?
4,500 to the hospital and 3,000 for minor child, total 7,500.
We were issuing notice.
Where my lord, my income is 7,000.
Heard Mr. H.A. Ahmed. R. Ali. H.A. Ahmed, learned counsel for the petitioner. Also heard, stop. This application under section 438/442 of BNSS has been filed by the petitioner impugning the judgment and order dated 29/7/2025 passed by learned Principal Judge Family Court Borpeta in FC within bracket criminal case number 17/2023, whereby the petitioner has been directed to pay a monthly maintenance allowance of rupees 4,500 to the respondent and rupees 3,000 to his son, within bracket total 7,500. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
This criminal petition preferred against the NBWA. However, during the pendency of the NBWA, yesterday I was arrested.
Okay, then you have to appear.
Already arrested.
You are withdrawing this.
Withdrawn.
Heard Mr.
Matter become infractionous.
H.R. Chaudhary, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition as it has become infructuous due to the arrest of the petitioner. Stop considering the submissions made by learned counsel.
And however,
This,
invited to appear before the learned court.
no, this criminal petition is dismissed on withdrawal.
22.
Lordship, this petition has filed for quashing of NBWA and proclamation order, my lord. My lord, the petitioner was all along appearing after the framing of charge. My lord may be seen at page 30. The order
Yes,
sheet.
then what happened?
My lord,
When you defaulted?
Lordship, page 35, my lord, kindly see. On 5/2/2025, my lord, I was regularly appearing. On 5/2/2025, he was there before the court, my lord, and next date was fixed on 23/4/2025 for evidence. And on that day, my lord, he remained absent. And on that very day, my lord, NBWA issued page 35. My lord.
Okay, why you remained absent?
My lord, I have stated in para 5 of page number 4. My lord, I went out for my livelihood to Kerala, my lord, and it was
You
informed.
should have informed the trial
Yes,
court.
yes, my lord. My engaged counsel, my lord, I asked him to take steps on my behalf, but he failed to take steps on that day.
Heard me. Mr. M. Ali, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Muhammad Kalam Ali, impugning the order dated 23/4/2025 and subsequent orders passed by the Court of Learned Special Judge Kamrup Amin Gao, whereby non-bailable warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is facing a trial under section
20B of NDPS Act.
20B2B of NDPS Act in special NDPS case number 5/2021 before the Court of Learned Special Judge Kamrup Amin Gao. He submits that the petitioner was regularly appearing before the trial court till 5/2/2025. The next date of the case was fixed on 23/4/2025. Learned counsel for the petitioner submits that on that day, petitioner had to go to Kerala in search of his livelihood. While at the time of going to Kerala, he instructed his engaged counsel to take appropriate steps in the aforesaid case before the trial court. However, the counsel engaged by the petitioner failed to take such steps, as a result of which the trial court issued non-bailable warrant of arrest. Learned counsel for the petitioner has submitted that the petitioner is ready to face the trial and ready to appear before the trial court. When is the next date fixed? It is filed.
3rd of December 2025.
Ready to face trial, ready to appear before the trial court on the next date fixed, which is on 3rd of December 2025. I have considered the submissions made by learned counsel for both sides. Perusal of records indicates that up to 5th of February 2025, the petitioner was appearing before the trial court in NDPS case number 5/2021. He only defaulted from the next date fixed, that is 23/4/2025. Considering the submissions made by learned counsel for the petitioner, as well as considering the fact that the petitioner is willing and ready to cooperate in the trial, this criminal petition is disposed of with a direction to petitioner to appear before the trial court on the next date fixed, that is on 3rd of December 2025 in NDPS case number 5/2021. To facilitate his appearance before the trial court, the operation of non-bailable warrant of arrest issued against the petitioner by the trial court shall remain suspended till the next date fixed, that is 3/12/2025. On his appearance before the trial court, the petitioner may pray for any relief to which he is legally entitled to. This criminal petition is accordingly disposed of.
But, I may be allowed to appear before the court on or before my next date.
No, you appear on that date. Why?
On or before, my lord, I want to appear before 3rd of
No,
December.
but the court has fixed its case. Why to burden the court?
My lord, the protection is still 3rd of December, my lord.
Yes.
That's why, my lord. On or before, well, I shall appear on or before. 3rd of
No,
December.
not on or before. You appear on the day.
Obliged.
My lord, in this case, my lord, we have agreed by an order dated, my lord, 28/7/25, my lord. Starts from page 76 to 81, my lord. My lord, fact of the case is that, my lord, the respondent as complainant, my lord, she filed a DV case. Firstly, she filed a DV case. And when the proceeding of the DV case was going on, my lord, and settlement was done, my lord. And as per the settlement, I was to pay her a certain amount of money. And in that said agreement, it was mentioned that she will not file any more cases against me. The settlement took place, my lord, on 6th December 2017. After making the settlement, my lord, she again filed one maintenance case, my lord. That is annexure 4.
Under 125.
Under 125, my lord. Now, what happened is that, my lord, the counsel which I engaged, my lord, he did not conduct the case properly. And as a result, the case was decided ex parte against me, my lord. So I have also filed complaint against the said advocate, my lord. But unfortunately, my lord, to my knowledge, the said advocate has expired, my lord. Now, my lord, thereafter, my lord,
How much was directed?
my lord, expired is order, I think 5,000, my lord.
5,000. What do you do?
That is a government employee, my lord.
Okay, we are issuing notice. Heard Mr. I. Chaudhary, learned counsel for the petitioner. Also heard, no, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner Jahidur Rahman, impugning the order dated 20/12/2018. What is this 28/7 order?
Which order? Oh, there's a first order, my lord, whereby I was directed to, my lord, 20 order, my lord, at 28/9. 27/8. This is the my petition was rejected, my lord. Under 127, my lord. I filed a petition under 127, my lord.
Which order you are impugning now?
Both orders actually, my lord. Now actually we are challenging both the orders.
Both orders.
The main order is this, my lord. The one is, my lord,
Impugning the order dated 28/7/2025,
2025, and my lord,
passed by learned Principal Judge Family Court number 1 in
Miss case
number 175/2019 in connection with FC criminal case number 685/2017, as well as order dated 20/12/2018, passed by learned Principal Judge Family Court number 1, Kamrup Metro in FC criminal number 685/2017. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Until 24.
My lord, it's a series of case which is filed by the respondents at the behest of the magistrate itself, my lord. That is why magistrate has been made by name a party. Lordship may kindly see the High Court's order, page 45.
Yes.
Actually, there was one case, that is MR case number 66. This MR case number 66 and MR case number 215 are the same case between the same parties, but the one case is quashed by the Honorable High Court, that is kindly see page 46, because they are pending criminal case, a civil case. Kindly see page 4710. In view of the aforesaid, the present criminal petition stands allowed by setting aside and quashing the Amicus number 6623 under section 107, 145, 146, 1 of the CRPC, and all the consequential order passed by London Additional District Magistrate Hujai Shankardev Nagar, and also the notice that is so and so. So the same party again has filed another case that Lordship may kindly see page 69 regarding same plot of land. Page 69. Order dated 19/7/23. And again, another order was passed for the same plot of land, that is page 70, kindly see MR case number 215. 215, and that orders were issued by this Honorable High Court, that may be seen at page 73. Page 73, that was passed by your Lordship. Page 74 bottom, kindly see. MR case number 215, that is also there on the top of the order. And lastly, in the meanwhile, the impugned order of attachment dated 19/7/23 and 16/11/23, just now I have read. So both these orders have been kept in abeyance. Again, my lord, giving a new number, he has filed newly a case, that is page 13.
Page?
Page 13. This is his case. This is his case, that is the private respondent's case, and order impugned order page 15, Annex 2. Kindly see now the order, where is the party is present along with learned advocate. The second party is also present. The first party says that civil suit is pending in judicial court over the same disputed land. Once the order was issued by the undersigned on 4/11/24, stopping both from entering, but second party showed a Honorable High Court Guwahati order, quashing the earlier order issued by this undersigned on 4/11/24. But the undersigned, on examining the order of the Honorable Guwahati High Court, order dated 1/5/24 was done to quash the order in MR case number 66 that I have read just now. Further, on examining, the undersigned thinks that stopping both parties from enter a disputed property over which a title suit is going is most viable option to preserve which. Hence, the both parties stopped from entering the DL and bonds to be executed by O.C. Muradhar to maintain peace by the.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner. State is a party? No.
State is not a party, but the magistrate by name has been made a party.
This application under section 482 of BNSS. Sorry, this application under section 528 of BNSS has been filed by the petitioners, namely Ismail Ali and Asaruddin, praying for quashing of the MR case number 95/2024 under section 107/145 of the CRPC, and also impugning the order dated 17/7/2025 passed by learned Additional District Magistrate Hujai, whereby both the parties were stopped from entering into the disputed land. Learned counsel for the petitioner has submitted that the petitioner had earlier approached this court by filing criminal petition number 1297 for quashing of MR case number 215/2023, which was filed, earlier case was filed by the same petitioner,
My lord, same petitions.
which was filed by the same parties
Same parties and regarding same plot of land.
in respect of the same plot of land. In the said case, this court, by order dated
Order dated, my lord, 12/12/23.
no 12/12/2023 had stayed the further proceeding of MR case number 2195/2021 till the pendency of the said case. Learned counsel for the petitioner has submitted that now the respondent has again filed a
95, MR number 95.
again filed a new case in respect of the same property, which was registered as MR number
95/24.
MR number 95/2024, in which the learned additional district magistrate Ojai, though has stated in the impugned order that a title suit has been pending between the parties. However, in
The High
spite of
Court has quashed the earlier proceeding.
title suit has pending before both the parties. However, in spite of that, issued the directions to both the parties from not entering into the disputed land. So, learned counsel for the petitioner has submitted that the order passed by the impugned order passed by the learned additional district magistrate is beyond jurisdiction, as when a civil suit is pending before the competent court of competent jurisdiction in respect of a particular property between same parties, the executive magistrate does not have any jurisdiction to continue with a proceeding under section 107/145 of the CRPC. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. However, in the meanwhile, it is apparent from the impugned order itself that a civil suit is pending between the parties. Hence, there cannot be a parallel proceeding under section 145 of the RPC. Therefore, till the next returnable date, the further proceeding of MR case number 95 MR case number
Yes, 95/24.
95,
Order dated 77/25.
95/24. As well as order passed in the said case on 17/7/2025 shall remain stayed till the next returnable day. List accordingly.
Highly obliged.
Item 25.
Eight, please, Your Lord. This is an application under section 528, seeking quashing of FIR dated 21/4/2025.
21/4.
2025. The Lord will find the FIR translated in type copy and annexure to page 16. If I may read, Miller.
Yes.
Milord will find, may I point out, Milord, one thing, accused person, Milord, I am for the accused person number 1, and Milord will kindly see Ratan Boro alias Basumatari, unknown, village Rajapani, PS Palashbari, district Kamru. May I read, with due respect, I beg to state that on 17/4/2025.
You are accused number 1 or 2?
1. I am 1. At around 8 AM morning in Boko, Thursday Bazaar, following old grudge conflict with the intention to kill me, conspired and abetted by the accused person number 1, the accused 2 attacked me with sharp weapon and caused.
Now, what is your ground?
The whole incident took place between the respondent number 2 and one.
Instigation. Your accusation against you is that you instigated.
The person who has lost this information, I don't know him. Even he doesn't know me. Milord will kindly see.
Case diary would be required.
Yes, case diary would be. I don't have any. Whole issue is of Milord religious conversion, Milord.
Okay.
Because his wife practices Milord.
Case diary would.
They are already under interim.
Let the case
Heard Mr. N.B. Sinha, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, Shri Ratan Basumatari, alias Ratan Boro, praying for quashing of the FIR dated 21/4/2025, filed by the respondent number 2, on the basis of which Boko PS case number 116/2025 was registered. Stop. Let the case diary be called for. Let also notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by a registered post with AD, as well as by usual mode, within 7 days from the date of this order, returnable on 27th October.
along with the injury report, if any.
Case diary will.
Obliged.
28.
Is the petition praying for quashing of 498 applicating membership. Otherwise, the matter has been settled between the parties only because of the non-compoundable nature of the offense, Your Lordship.
What is the status?
It is sent for trial. The PW 2 and 3 are examined, Your Lordship, and the PW that have annexed, Your Lordship, they have stated in the evidence that it has been settled. And apart from that, page 19, annexure 3 is the memorandum of settlement.
But notice will have to go.
But
This is not a joint petition.
But the proceedings, Your Lordship, because the PWs are going on. And the PWs.
No,
are-
let the notice,
Let the notice be go, my lord.
let the respondent appear and say that it has
Lordship, I
been.
understand, but Lordship, once annexure 4, page 23, Your Lordship, the 2 PWs I have annexed, Your Lordship, they have stated, I have heard that they have amicably settled the dispute.
Heard.
And the memorandum is also before Your Lordship, where he
Heard
stated,
Mr. B.J. Mukherjee, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNS has been filed by the petitioner Irfan Khan, praying for quashing the proceedings of PRC case number 1346, 2023. Under section 498 of the IPC, read with section 4 of the Dowry Prohibition Act, pending before the Court of London, Judicial Magistrate First Class Tinsukia, on the ground that the matter has been amicably settled between the parties. Stop. Let the notice be issued to the respondent. Number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Placing for the interim because your lordship is a resident of Guwahati and the case is pending at Tinsukia, your lordship.
Case is pending at
Tinsukia. Petitioner is from Guwahati.
list this matter on, instead of 4 weeks, returnable on a short date. 23rd October.
Please, your lordship. Application number 528 of BNS.
Yes.
Affair is 13.
What is your prayer?
Quashing of
Washing off?
FIR.
What is the stage? Pending investigation.
That's it, not fine. The case was registered in the year of 2022. In the meantime, search is not filed, and I am not involved in this case.
We'll call for the case diary. Heard. Heard Mr. N. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Shah Jahan Ali, praying for quashing of the FIR lodged by respondent number 2, on the basis of which Lahori Ghat Police Station case number 191/22 was registered. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2. By registered post with AD as well as by usual mode within 7 days from the date of this order. Let the case diary be also called for. Let this case be listed on 29th October.
29.
Please, your lordship. Here, person is in custody since December.
Copy has not been received.
My lord, may pay for my lord consideration. My lord, 9 months has elapsed, my lord, in custody. Here, my lord, the affair goes to show that the offense is under, at best it may be under section 7 of the POCSO Act. And punishment under that category is only up to 5 years.
No, scan copy would be required.
That will be required and also lordship the respondent.
My lord,
Notice to respondent number 2.
today is the 5th day, I think. 5th day.
I was.
Yes, July onwards, my lord.
You have not taken information.
No, I tried lordship, but somehow lordship skip lordship. So lordship, both the date may be fixed for both the things.
Okay. Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. The office note dated 23/9/2025 shows that the scanned copy of the trial court record has not been received. Issue reminder for the same. It also appears that learned additional public prosecutor has also prayed for some more time for taking information regarding the fate of the notice issued to respondent number 2. Stop. The prayer is allowed. Let this matter be listed on 23rd of October.
Party.
My pleasure, Lordship. The petitioner was arrested on 17/11/2024 to this 312 days. The scan copy was called for moment here already suscited moment and charges frame moment under section 64 BNS and 6 of POCSO moment. And the alleged victim already examined is 15 of my petition. And the girl and boy moment, they are not so different of the age manner. Somehow he completed
Page number?
Page 18, sorry, page 15. Page 15 is the statement of the girl mother.
Why the trial court rejected your prayer?
But that is page, I have an estimate, page 30. Madam. Earlier also rejected, but on order I have next year. I am praying, my lord, that he is facing trial, my lord, the opportunity may be provided so that he can also collect his defense witness. My lord. What will be the finding of the case, my lord? Nothing to say because it will go as per evidence, my lord. So I am praying only that he is a local person and under any terms condition, honorable court may consider so that he can face the open trial.
Yes.
Here, Lordship, altogether, till date, Lordship, 3 PWs have been examined, including the victim and her parents, Lordship. And Lordship, so far the allegation goes, Lordship, at the time of FIR, Lordship, she was around 16 years of age. Her date of birth is 2/7/2008. And she, in her statement, Lordship, in all the statements, Lordship, she has categorically stated that they were in a relationship for the last 3 years, Lordship. And the first sexual intercourse, Lordship, that happened in July 2022. So, Lordship, that means, Lordship, she was around 14 years, 13 to 14 years, Lordship, at the time of occurrence, first time of occurrence, Lordship. So it squarely comes under Lordship POCSO Act. So that part, Lordship, will have to see.
Okay. Yes.
I think, my lord, then she proposed first time in her evidence, he's saying, I proposed him. And he said yes. I think,
I would not have objected, but here case is different. Lordship. Here, Lordship, false promise of marriage that to a minor. And in fact, if your Lordship peruses their petition, Lordship, I have not found anywhere that he intends to marry. That statement is not there. And the main Lordship thing your Lordship will find, page 15 of their petition, the position part, Lordship. Here also, Lordship, that he approached the girl with a promise to marry her. And with that intention, Lordship, physical relation was done, Lordship. And subsequently, Lordship, he refused to marry. That also, Lordship, a relevant fact, and that too a minor girl, Lordship. And regarding, Lordship, her bail, Lordship, page 17, Lordship, can you say last line? That she has, during cross, she was asked whether she has any objection, and she has categorically said that I have objection to the bail of the accused, and I do not want him to be bailed out. Minor girl, Lordship, that false provision of marriage, that part is there. And in fact, had it been a case that the petitioner has stated in his petition that he is willing to marry, that would have been a different aspect, Lordship. Clear
That
lordship, this is a case of clear exploitation.
At
lordship, of a
present,
minor
that
guy.
aspect cannot fulfill because how the marriage will solemnize man? He is still now not marriageable age now. And she stated that she proposed him first time. in
No,
phase,
without going into
15.
merits, any other reasons for refusing bail? Yes, Mr. Sharma, or any other independent witness?
I've seen. Police personnel and the doctor. also.
Yes, you have any other ground? Okay. Heard. Mr. Ainuddin, learned counsel for the petitioner. Also heard. How many total witnesses are there?
6 probably looks. I'm not wrong. 6.
Also heard. Mr. B. Sharma, learned additional public prosecutor, as well as Mr. A. Ahmed, learned legal aid counsel appearing for respondent number 2.
5 witnesses are there.
This application under section 483 of BNSS has been filed by the petitioner, namely Abdul Ali, who has been detained behind the bars since 17/11/2024, within bracket 312 days, in connection with Sessions Special Case Number 21/2025, arising out of Nunma TPS case number 226/2024 under section 64/64 of BNS, read with section 6 of POCSO Act, pending before the Court of Learned Special Judge POCSO, Kamrup Metro. Learned counsel for the petitioner has submitted that the petitioner is facing a trial under section 64 of BNS. 6 is penetrative sexual assault.
Yes.
64 of BNS and section 6 of POCSO Act. He further submits that the petitioner and the victim girl were in a relationship before lodging of the FIR. He further submits that out of 5 listed prosecution witnesses, 3 have already been examined by the trial court, including the petitioner, including the victim girl. He therefore submits that, considering the progress of the investigation, as well as the fact, progress of the trial, as well as the fact that the victim girl has already been examined, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that in her testimony before the trial court as PW1, while deposing as PW1, the victim girl has categorically implicated the petitioner. She has learned counsel for the learned additional public prosecutor has also submitted that the victim girl was of about 14 to 15 years of age when the alleged incident was committed. Learned Amicus Curiae, Mr. A. Ahmed, has also opposed the grant of bail on the ground that there are sufficient materials against the petitioner in the case diary. And here he further submits that the petitioner committed penetrative sexual assault with the victim girl on the pretext of by giving her false promise of marrying her. He also submits that the victim girl has also stated that she has objection to grant of bail to the petitioner. I have considered the submissions made by the counsel for both sides. Though the victim girl has implicated the petitioner in her testimony while deposing before the trial court as PW1. However, it appears that both the victim girl and the informant, that is respondent number 2, have already been examined as prosecution witnesses in the trial, and only 2 remaining witnesses are left to be examined. And they are only witnesses in the category, they are only official witnesses. Stop. Also considering the fact that the petitioner has been detained behind the bars for last 312 days. This court is of considered opinion that if the petitioner cooperates in the trial, his further custodial detention may not be necessary for fair completion of trial of POCSO Sessions Special Case number 21/2025. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with 1 surety of like amount, subject to the satisfaction of London Special Judge POCSO Kamrup Metro, with following conditions, with a condition that he shall continue to operate in the trial and shall not directly or indirectly make any inducement, threat, or promise to any of the remaining witnesses so as to dissuade such witnesses from deposing before the trial court. This bail application is according to this court.
I will not take any undue adjournments.
Undue?
Adjournments, without any not showing any cause for that.
No, I am not getting it.
Lordship, adjournment will not be sought by him on unnecessary grounds. Because normally
Ultimately, court without
it happens.
reasonable ground never adjourn the
There are only 6 witnesses. Lordship. It is
The
also
trial court is also directed to make all endeavors to dispose of the aforesaid case as expeditiously as possible.
Item 31.
The last occasion also, Lordship, they did not appear.
None appears for the petitioner on call. Mr. B. Sharma, London Counsel for the London Additional Public Prosecutor representing the state is present, as well as Mr. S. Singh is also present for the informant. On perusal of the records, it appears that on last occasion also, that is on 11/9/2025, none has appeared for the petitioner on call. It appears that the petitioner is no longer inclined to pursue this bail application. This bail application is accordingly dismissed due to non-prosecution.
32.
None has appeared for the petitioner on call. Mr. B. Sharma appears for the state Mr. B. Sharma learned additional public prosecutor appears for the state. It also appears that the notice issued to respondent number 2 has not yet returned. Await further. List this matter after Puja vacation on a date to be fixed by registry.
33.
33 Lordship, charge sheet has been submitted.
Heard Mr. M. K. Shah, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid.
In charge sheet number 116.
Bearing charge sheet number
116/25 dated 24/8/25.
This is what case?
POCSO case, Lordship, 6 of POCSO.
Lordship, the petitioner was arrested on 27/6/2025, Lordship.
On filing of the charge sheet, this anticipated bail. Oh no. As the charge sheet has been laid, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court if so advised.
Item 34.
Yes.
Lordship, in this case, Lordship, I am father-in-law of victim girl, Lordship. Lordship, son of the petitioner and victim girl developed their relationship of natural love, Lordship. And accordingly, and in order to their relationship of love voluntarily, they eloped from their respective houses.
Be louder.
Lordship, already they have one child, Lordship. Lordship, marriage was solemnized in the year 2021, Lordship. And they have one child, Lordship.
Okay.
Lordship, yeah, Lordship, I am father-in-law of the victim girl, Lordship.
He is the father of the groom, Lordship.
He is behind the bar.
He is
Yes.
also,
No,
yes.
only the 10 months on interim bail, on last date, madam.
You are on interim bail.
Okay, Lordship. On
Case diary is there.
His there is there, Lordship. Only thing, Lordship, he is the father-in-law, Lordship. He arranged the marriage. And
No, Lordship.
apparently,
He has
Lordship-
cooperated. No, his statement has been recorded.
Yes.
Heard Ms. P. Adhikari, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. A. K. Azad, learned counsel, appearing for respondent number 2 or 3. Respondent number 3. Within bracket, the victim. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by order dated 1/9/2025 by this court, and that he has not violated any of the conditions of the bail and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Dubri PS case number 340/2025 and has submitted that the statement of the petitioner has already been recorded and he happens to be the father-in-law of the victim or groom,
Groom looks.
father-in-law
No,
of
no,
the
father of the groom looks. Sorry.
father-in-law of the victim girl, and his role is to the extent of arranging the marriage of the victim with his son. He further submits that the investigation has fairly progressed. So, considering the fact that the petitioner has not violated any of the conditions of the interim bail, as well as also considering the progress of the investigation, the interim bail granted to the petitioner by order dated 1/9/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. This bail application is accordingly disposed of.
35 Lordship, there is an office note dated 16/9/25 Lordship. The service report is still awaited Lordship.
POCSO matter.
Yes.
May I plead your lordship? I am behind the bar for last 112 days. FIR is on.
It is pending investigation.
No Lordship.
Service.
Examination of victim and the informant is also open. And
Magistrate will
only-
be appointed.
Highest number and 3 years only imprisonment.
We'll
Page
appoint
number
one
13.
amicus.
Page number 13. your lordship. My only allegation is that I hold her hand. This is the only allegation.
Page number
13, 1-3. Charge sheet has been framed. May I read?
where is the statement of the victim girl?
I don't have Xerox copy because
It is in the can copy. I have trademark victim. She is a school going girl and he is a auto rickshaw puller. And her statement may be granted. There are materials against the person. He tried the girl somehow escape from the place. In rainy season.
Okay, we'll appoint one amicus curiae,
your lordship,
or we'll wait for service of notice.
actually, I am behind the bar for last 115
But
days.
victim has a right to.
Examination of 4 witnesses is complete.
How many witnesses are there?
5. Today is another date fixed for evidence.
Dear Malak,
We have copy of 3
informants statements are
and most importantly, examination of witness, statement of victim and the informant completely inconsistent regarding the time, place and everything.
victim is a vital witness, Malak. Victim's statement is there. Let the amicus may be appointed, Malak. Immediately after vacation, Malak.
Okay, heard Mr. What is your name? R. Day, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. There is the office note dated 16/9/2025 shows that the service report in respect of respondent number 2 has not yet been received. So, learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since for how many days?
Since 3/6/2025,
For how many days?
more than 112 days.
For last more than 112 days. He also submits that in the meanwhile, the victim and the informant have already been examined by the trial court. Considering the submissions made by learned counsel for the petitioner, petitioner, instead of waiting for the service report of the notice issued to respondent number 2. This court is inclined to appoint one amicus curiae to defend the cause of. Any amicus present? Defend the cause of respondent number 2 in this case. Accordingly, Mr. Nimish Mahajan is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish a copy of bail application along with the annexures to the newly appointed amicus curiae. Registry to reflect the name of Mr. N. Mahajan as amicus curiae for respondent number 2 in this case. List this matter 15th of October.
Could it be a closer date?
Closer, it will fall within vacation.
46.
Yes.
Well, this is my case. He has been arrested on 29/11/2023, 1 year, 9 months and 27 days. Offense report filed on 25/2025, charges framed on 21st of October 24. My lord, this will be 25, it has wrongly been typed as 24. And number of witnesses till date examined, no witness has been examined till date. And these are the grounds, my lord. Prolonged incarceration on that very ground, my lord, perhaps. Your lordship has passed.
Only one witness, only one accused.
These are two, there are in fact, my lord, 1, 2, 3, 4 accused persons. One has been granted bail by the court below. And this bail application is for 2 of them. And there is the next item is for the other one.
Yes.
Final complaint filed on 25/24. After that, lordship, several dates were fixed for consideration of such, but charges could not be framed because lordship, opposite party, accused person did not engage any advocate, lordship. In between, lordship, counsel for the petitioner number 1 and 2 also took time, lordship. Finally, lordship, charges frame on 21/10/24. And after that, lordship, in between, 2 witnesses were present, lordship, but lordship, they could not be examined.
Delay was due to your.
Absolutely not, my lord. That because I am inside the jail, my lord. How can the delay be attributable to me? I am inside the jail.
No, you took adjournments.
Adjournment in.
When the witness.
No, lordship, when the witness were present, lordship, court was not functioning. Officer was on.
The presiding officer was on leave.
I have flag mark, lordship.
Not because
But,
of.
when the charge, dates were fixed for framing of charge, lordship.
How much is the contraband?
Contraband is, my lord,
9.660 kg.
660.
Methamphetamine.
Methamphetamine.
And contraband recovered from the position of the petitioner's, lordship.
And moreover, my lord, the grounds of arrest were also not being
Grounds
communicated.
of arrest, lordship, at the time of his arrest, they accepted arrest memo, lordship, and which was specific to the petitioner, lordship, and their side signature was their, lordship, and their wife was also there in the train from where the contraband was recovered, lordship. That is why bail was rejected recently on 29/8/25, lordship. Their wives were there, lordship, in train, lordship.
Now, my lord, if she's done with her
Clearly
submission.
mentioned in paragraph number
Let
5.
her submit,
Yes,
let her
let
submit.
them, let her submit. I'll make a counter.
clearly mentioned in paragraph number 5 and 10 of the final complaint, Lordship. That is why Lordship bail rejected recently, Lordship.
When bail was rejected?
29/8/25, Lordship. Their bail was rejected by the trial court, Lordship. I have flag marked the order, Lordship.
Okay.
And regarding Lordship, co-accused, bail was granted to co-accused, but Lordship, he was soon arrested. Section 50 notice was not served to them, Lordship. Here, Lordship, arrest memo was served to them, Lordship.
And 48 notice?
48 notice also, Lordship, it was issued through registered post on 29/11/23, Lordship. It is clearly mentioned on the order of 29/8/25, Lordship. I have flag mark, Lordship.
Okay, I'll go through it. Anything?
Now, my lord, first thing is that there was no adjournment taken by the accused person during the trial for examination of the witnesses because, my lord, the presiding officer was on leave. This is one. Second, my lord, what they're saying is that they're making some, my lord, these submissions regarding arrest memo. Already our High Court, 3 benches of our High Court have categorically held that such arrest memo will not suffice the mandate of Article 22 or for that matter, Section 50 of the NDPS Act or for that matter, Section 50 of the Art 12 CRPC. My lord will kindly come to this arrest memo. It is neither here nor there. It simply says.
Where is the arrest
Yes,
memo?
my lord. Page number 52. Does it communicate how?
Page number?
52. For petitioner number 1, page 52. For petitioner number 2, page 53. These are the same arrest memo.
Yes.
Now, my lord will kindly see the arrest memo. In connection with recovery of seizure of such and such under section such and such, as amended such and such at such and such Guwahati railway station, I do hereby arrest such and such aged about such and such from Manipur. This is the under section 42, such and such as amended such and such. On reasonable belief, prima facie proof that the seized goods are liable for confiscation. Goods are liable for confiscation under section 60 of the NDPS Act. And the aforesaid BM race is liable to be prosecuted under section 8C, 22C, 29. Now, my lord, 8C contemplates as many as 13 sub-offenses. 8C, the section 8C of the NDPS Act contemplates as many as 13 sub-offenses. It includes import, export, transport, carrying, possessing.
No, they could have simply stated that it was found from your possession.
Absolutely.
Instead of
making it
writing
so clumsy.
So clumsy and without mentioning the
Exact
correct
role
that it was found from your possession.
Because these regarding such arrest memos, because my lord, in all NDPS NCB cases, they use the same format. They have this format printed in their office. And my lord, I can show that judgment where this court have held that such arrest memo will not withstand the test of Article 22. I can give that case number also. One by your lordship and the other by Justice Thakurian.
Miss Deka, you can instruct the NCB officials that in most of the cases, due to defective notice, the accused persons are getting bail. Still, they are continuing with the.
No, nowadays, my lord, the recent cases which I am handling, my lord, now they have not only this, they give exact role with para-wise and everything.
Heard Mr. M. Bishwas, learned counsel for the petitioner. Where is the judgment which you are relying? Heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Ms. M. Deka, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely B.M. Rashish and B.M. Hafiz Anish, who are detained behind the bars since 29/8/25 11/2023 within bracket for more than 1 year, 9 months in connection with NDPS case number 183/2024 corresponding to NCB crime number 19/2023 under section 22C/29 of the NDPS Act, presently pending before the Court of London, Additional Session Judge number 5, Kamrup Metro. The gist of accusation in this case against the petitioners that on
Para 3, page 3.
on 27/11/2023, the intelligence officer of NCB received an information through reliable sources that 2 persons within bracket present petitioners are likely to arrive at Guwahati railway station at about 6:30 p.m. Stop. Accordingly, the NCB officials reached the Guwahati railway station and conducted the search of the train in which the petitioners were traveling. During search, during search operation, about 9.660 kgs of contraband suspected to be methamphetamine tablets were recovered from their possession. Learned counsel for the petitioner has submitted that though the petitioners were served with the arrest memo, which was prepared after their arrest, however, same does not mention the grounds of arrest and the basic facts for which the petitioners were arrested. It does not clearly mentions about the accusation made against the petitioners. He further submits that, and as such, there is a violation of Article 22 within bracket 1 of the Constitution of India in this case. He further submits that the petitioners are languishing behind the bars for last 1 year, 9 months, and none of the 9 prosecution witnesses have yet been examined. And therefore he submits that due to the prolonged incarceration of the petitioner, his fundamental rights their fundamental rights guaranteed to them under Article 21 of the Constitution of India has also been violated. On the other hand, learned counsel for NCB has vehemently opposed the grant of bail to the petitioners on the ground that the contraband seized in this case is of commercial quantity, and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. She further submits that the delay in culmination of trial cannot be attributed to the prosecution side, as the delay was caused due to failure of the petitioners to engage their counsels at the initial stage. He further submits two witnesses.
On 24/1/25.
She further submits that two witnesses were also present before the court on 24/1/2020. By 24/1, but charges were framed on 21/10.
These are all 2024. This is a print,
Okay.
typological error, my lord.
Okay.
These are all 24. There is nothing in 25.
24/1/2025. However, they could not be examined as the accused persons took adjournment, no, as the court was vacant on the date of appearance of the witnesses. I have considered the submissions made by learned counsel for the petitioner, as well as learned. I have considered the submissions made by learned counsel for both sides and have gone through the records available before this court, including the scanned copy of the trial court records. It appears from the notice under section 40, notice under section 50 of CRPC, which was served on the, no, it appears from the, on perusal of the arrest memo. Where is that arrest memo?
Arrest memo for petitioner number 152 and for petitioner number 253.
Arrest memo.
And notice 50 CRPC notice 54. Page 54 is 50 CRPC notice. Even in 50 CRPC notice, page 54, there is nothing.
It appears from the notice under section 50 CRPC issued to the petitioners at the time of their arrest, that said notice does not contain any grounds of arrest, as well as basic facts. In basic facts which necessitated the arrest of the petitioner in the above noted case. It also appears from the memorandum of arrest prepared by the arresting officer at the, after the arrest of the petitioners, that though the said notice mentioned that the petitioner was arrested in connection with the recovery and seizure of 9.669 kg of methamphetamine at Guwahati railway station. However, it is not indicated therein as to how the petitioners are linked with the said seizure. Nowhere in the memorandum of arrest it has been stated that the contraband was recovered from the possession of the present petitioners. Thus, though the memorandum of arrest mentions about the legal provisions, as well as mentions about the penal provisions under which the case has been registered, it is devoid of clarity, which would indicate to the petitioners the grounds of arrest. Further, it appears that the petitioners are languishing behind the bars for last more than 1 year, 9 months. which in the considered opinion of this court is is a period of incarceration which may be regarded as long enough to have infringed the fundamental rights of the petitioners guaranteed under Article 21 of the Constitution of India. And as such, it overrides the embargo of Section 37 of the NDPS Act. And therefore, this court is of considered opinion that the petitioners are entitled to go on bail. For the aforesaid reasons, the above named petitioners are allowed to go on bail of 1 lakh each, with one surety of like amount, subject to the condition of none, subject to the satisfaction of the trial court with following conditions. Conditions, Abhishek or Pranay. And next item,
Everything same, everything same. Next item is even a better case, because in next item it is a shown arrested case, no arrest memo or section 50 notice was issued. Even she will agree to that.
Because Lordship, he is involved in 2 cases, Lordship. Kindly mention this, Lordship. He is involved in NCB crime number 20/23.
okay, next item we will take up at 2. For reasons mentioned in the judgment, this criminal revision petition is dismissed.
Your Lordship. Lordship, I beg to mention this matter for listing, Your Lordship. This matter was listed today in court number 25, Your Lordship. But somehow the Honorable Court didn't sit today. So I'm praying for getting it listed tomorrow, Your Lordship, because
What is the matter?
Your Lordship, he will almost cross his statutory period of detention if the matter is not listed tomorrow, Your Lordship. Bail matter.
If it is crosses statutory period of detention,
No,
you will automatically get bail.
Your Lordship, after 10
Where is the
15
urgency? There is no urgency.
After 15 days, Your Lordship, now it's still 15 days is short, but during the vacation, Your Lordship. So I'm praying, Your Lordship, to get the matter listed.
Tomorrow.
Obliged.
Lordship, a similar prayer is there, Lordship, in court number 25. I had a bail hearing item number 44, Lordship. But Lordship, according to the notification, Lordship, I was supposed to mention in
Tomorrow.
Lordship.
May please, Your Lordship, similar prayer, Your Lordship. My also matter was listed on.
Tomorrow.
Your Lordship, one is my case, Your Lordship. DA 1130/25. This matter was picked by this honorable court on today, but not this. Your Lordship.
Tomorrow.
That's it, item number 39 of yesterday's list in respect of court number. That's it, that may be something. Today it was listed before this honorable justice.
What is the matter?
It is Lordship, trial is going on, but from the initial date of arrest, he is behind the bar. More than 6 months.
Immediately after reopening.
Lordship, can it tomorrow? Because
Tomorrow it will not reach, even if we list.
let it be listed tomorrow, Lordship.
Okay, tomorrow.
Item number 61 of today's list, Lordship, IA for correction of order is there. That I may be allowed to withdraw. So that correction is condoned by the trial court itself as type of appeal error.
Okay.
Item number 61.
Heard Mr. A. Ahmed, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw this interlocutory application, as it has become infructuous. The prayer is allowed. This interlocutory application is dismissed on withdrawal.
Obliged.
Products only cited proof for withdrawal.
Heard Mr. What is your name?
Muhammad A. Rahman, Your Lordship.
Muhammad A. Rahman, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Prayer is allowed. This application is dismissed on withdrawal.
Highly obliged, your lordship.
Item 37.
This is the,
Same as the item number 36, Lord.
this is allowed. We are allowing this petition on same term.
NCB card number 20/22. He is a repeated offender, lordship, kindly mention. Lordship.
Is the same,
Yes, Lordship, same. In this case, he is thrown arrested, Lordship.
Status will be same, lordship.
what was the contraband?
Methamphetamine.
Methamphetamine. We are allowing it on the same ground. Okay, okay, that your objection will be mentioned. Yes. On same terms and condition. This, some corrections will be required. I will make in chamber.
I agree.
38.
Lordship, regarding illegal mining at Nangshu Milo, page 11 is the FIR.
Case diary is there.
Yes, Lord.
What is the date of your arrest?
Lordship, he was arrested on 23/8/25 Mile.
How many days?
3 days as of today, Mile. And apart from this, my lord, he is the manager, Mile, the prime accused, Mile. And that is reflected in the forwarding report itself.
Yes, Mr. Sharma.
I have objection also regarding the release of this present petitioner. Lordship. If Lordship allows me, I can place the facts. Lordship.
Yes.
Lordship, here it relates to illegal coal mining, Lordship, as a result of which 9% has died, Lordship. If Lordship kindly comes to page 13, the forwarding, Lordship, I may just place the relevant facts, Lordship. The FIR was lodged on, Lordship, January 25, Lordship. To be specific, Lordship, on 6/1/25. FIR.
What is the progress of the investigation?
Yes, Lordship, regarding that only I would like to show something, Lordship. There are other persons who are involved, Lordship, who are associated with the illegal mining, Lordship, whereby it is banned in that area. But even after that, they have been carrying on illegal mining there, as a result of which, Lordship, one unfortunate incident happened and 9% were kept in the red hole, Lordship. And they could not be recovered after a while, Lordship, their dead bodies were recovered. Lordship, the equipments provided, the mining tools, financing, all those aspects are going on, Lordship. He is the manager, Lordship. In fact, Lordship, he is the main person who operated the mining hole, Lordship. There, Lordship will find, if Lordship kindly comes to the.
What is the statutory period
Statutory period, Lordship.
of the offense?
Yes.
What is 105?
Culpable homicide not amounting to murder.
How much is the punishment?
And
You are not ready.
Imprisonment for life. Culpable homicide, imprisonment for life.
In this case, Lordship, all the accused, my lord, they were granted by your Lordship itself, my lord. And he is the manager, my lord, main accused, my lord, prime accused, manager, he was also granted bail by the landed trial court.
Lordship, here, Lordship, I have to make this submission, Lordship. The FIR is of 6/1/25, Lordship. He was arrested very recently, Lordship. After 8 months, he was absconding. First, he was in Meghalaya, then he went to Silchar. After tiring efforts by the IO, Lordship, he has been arrested. And Lordship, his bank account transaction are being verified, Lordship. It shows there's been transaction of more than 2 crores rupees, Lordship. And some of the important co-accused are yet to be arrested, Lordship. Because, Lordship, the mining, Lordship, it has been done by different persons, Lordship.
That is also reflected by the rejection order, Lordship. So at least for some more days, Lordship, he needs to be.
Why do you need his?
Lordship, to break the chain, Lordship, because all their co-accused are yet to be arrested, Lordship.
Heard Mr. J. Laskar.
My lord, may I submit one to you? In the grounds of arrest, my lord. Lordship, kindly have a look, page 14, my lord. Page 14, my lord, this serial number 5. Investigation, Lordship, page 14.
Yes.
Investigation of the case also revealed that the arrested person, so-and-so, 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 are the manager of the prime accused, Punush Notisha, and they not only look up the financial matter, but also supplied machineries to the illegal coal mining at Kamaka. Now, my lord, the petitioner before your lordship is the manager of the main prime accused, my lord, as per their forwarding report. And he was also already been granted bail by the Lane trial court, my lord, on 6/3/2025.
Where is the bail order?
My lord,
Heard Mr. J. Laskar, learned counsel for the petitioner. Also heard Mr. K. Kepa. Also heard Mr. B. Sharma, learned additional public prosecutor. On what ground he was?
considering the length of detention, my lord. And the similar order I have annexed lordship also.
Okay.
Lord.
Okay. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Jamal Ali alias Sona, who has been detained behind the bars since 23/8/2025 within bracket for last 53 days in connection with Umrangshu PS case number 2/2025 under section 105/2000/3 within bracket 5 of BNS, read with section 21 within bracket 1 of the Mines and Minerals within bracket Development Regulation Act 1957.
Lordship, I'm sorry, 31 days, Lordship.
51.
31 days. He was arrested on 23.
Only 31 days.
No, my lord. He was arrested on, my lord, 23/8/2023. Today, 33 days.
Only 33 days.
Now, my lord, in similar accused, my lord, I have annexed in the order. He was granted almost 40 days.
Lordship, he is in a defense footing.
Okay.
My lord, admittedly.
No,
my
you
lord-
cannot continue arguing intermittently.
Sorry.
You have to complete your submissions.
Sorry.
What is your submission?
My lord, admittedly, he is the manager of the, my lord, crime accused as per their forwarding as well as, my lord, arrest memo, my lord. And it is specifically stated there, my lord. And as far as, my lord, the allegation is concerned of illegal mining, my lord. This petitioner, there are, my lord, some high-handed persons are there, my lord. And lordship, he is being the scapegoat, my lord. Scapegoat, my lord, he has been.
Why do you need manager?
Lordship, to break the chain. That is why, Lordship, I wanted to show the rejection order, Lordship, because it has been done by a number of persons. The mining is banned from 2020. Several influential persons are there, Lordship. He is the one who gives the logistic support.
But he is only the manager of
No,
the.
Lordship. Yes, Lordship. He is the manager, Lordship. He is in charge of all the mining operation. He arranges the laborers, the equipments, the transaction that has been done, money trail. It's from his account, Lordship. Both two accounts are in scrutiny, Lordship. There are two
Okay,
crores of
okay.
transaction are there. And furthermore, Lordship, if I may just point out, he arranged the laborers on that day when they were asked to go into the mining hole, Lordship. After they died, Lordship, post-mortem was done. They died of drowning, Lordship. Knowing fully well all these things, Lordship, it was done deliberately, Lordship. That is why, Lordship, and the other co-accused are still absconding, Lordship.
Lastly. Mines and Minerals Act. Mines and Minerals within bracket Development and Regulation Act. The gist of accusation, court para plea from page 19. Learned counsel for the petitioner has submitted that the petitioner is only manager of the main accused. Where is the forwarding?
Lordship, page 14, my lord. Paragraph 5, my lord.
Main accused.
No. Page 14, my lord, serial number 5.
Main accused. Punush Nunisa. And he only looked after the financial matters. So he submits that the said accused has, the main accused has already been granted bail by the Court of Learned Sessions Judge Rima Hasav, considering the period of the detention. He further submits that some other co-accused persons are also released on bail. And therefore he prays that considering the period of detention, the petitioner may also be allowed to go on bail. He further submits that petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Umrangshu, PS case number
2/24.
PS case number 2/2025, and has vehemently opposed the grant of bail to the present petitioner. He submits that there are sufficient incriminating materials against the petitioner in the case diary, indicating to the fact that it is he who manages the illegal coal mining, which resulted into death of 9 laborers. And he used to supply the machineries for illegal coal mining at Kalamati area. He further submits that the bank accounts of the petitioners are under examination, which shows transaction of huge amount of money. He further submits that petitioner does not stand on the same footing as that of the other petitioners, other co-accused, as he has completed only 33 days behind the bar, whereas main accused was granted bail considering the period of detention, his period of detention within bracket 58 days. Stop. I have considered the submissions made by learned counsel for the petition, learned counsel for both sides, and have gone through the materials in the case diary. Stop. The case diary reveals that there are sufficient materials against the present petitioner, indicating to his complicity in the offense alleged in the FIR. It also appears that some of the co-accused are yet to be arrested. Further, he does not stand on the same footing as that of the released accused person, namely Punush Nunisa, as he was released on bail after completion of 58 days behind the bars, whereas the present petitioner has completed only 33 days, and the and his custodial interrogation. Custodial interrogation is necessary,
It is necessary because the names of the.
and his custodial interrogation may be necessary for further custodial interrogation may be necessary for fair completion of the investigation. For aforesaid reasons, this court is reluctant to grant bail to the petitioner at this stage. Send back the case file.
Inadvertently, Lordship had again mentioned it as 50, not 50 days, that means.
33, 58 prime accused.
40.
Yeah, Lordship. My lord, petitioner, my lord, behind the bars for 2 years, 2 months.
Service report is awaited, Lordship.
POCSO.
Yes.
POCSO, my lord.
Oh.
My lord,
Steps were taken on,
15
When?
steps were received on 18/9, Lordship.
My lord, grounds of
By
arrest,
our office.
we have not communicated.
No,
my
why
lord.
you have not taken steps?
On 18,
By
it was. carried. Even
By
on
registry,
18.
Lordship, on 18/9.
You were directed to take steps within 3
I-
days.
I have given, but my clerk.
We heard Mr. S.K. Sigdar, learned S.H. Sigdar, learned counsel for the petitioner. Also heard Mr. K.K. Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 23/9/2025, it appears that the service report in respect of notice issued to respondent number 2 has not yet been received. In view of the aforesaid office note, the learned additional public prosecutor is requested to get information regarding the fate of the notice issued to the respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Let this case be listed on 23rd October.
Hello.
42, Lordship, charge sheet has been submitted.
Heard Mr. A.A.R. Karim, learned counsel for,
This year may kindly call for this.
what is the matter?
NDPS, commercial confidence. Let them first approach the court below, Lordship.
What is your case?
I am passenger, your lordship, that passenger car, your lordship, some articles were recovered, your lordship.
You please place your case before the trial court.
Yes.
Also, Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
170/25 dated 18/8/25.
Considering the fact that the charge sheet has been submitted, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before such court, if so advised.
43 and 44, Lordship, arise out of the same affair. Here, Lordship, the CD has not been received.
CD has not.
Not been received.
My lord, in 43, I am in custody since 46 days, lordship. And the allegation under intermediate quantity, lordship,
How much?
3.3 kg, 285 gram ganja, lordship,
3 kg only.
3 kg, lordship.
And in the next case,
2-0. The next case, lordship, we have petitioner is behind about for 32 days.
how
And
much?
Quantity of ganja, lordship, that was like 2.69. Just fine. My case is lordship, Bongaga
Why
PS.
the trial court rejected your prayer?
My case is lordship, Bongaga PS case number 220. But his case is 205.
I'm sorry.
Oh, separate case.
Separate.
Okay, we'll take it.
Lordship, they have not annexed the rejection order probably.
Forty-three, 46 days is sufficient time for conducting.
Lordship, but NDPS, Lordship.
Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Dinabandhu Das alias Dinabandhu Das, who has been detained behind the bars since 11/8/2025 in connection with Bongaigaon PS case number 205/2024 under section 20B2 within bracket capital B of the NDPS Act. The gist of accusation in this case is that on 10/8/2025, one Bhaskar Bora had lodged an FIR before the officer in charge of Bongaigaon Police Station, inter alia, alleging that an information was received that one person within bracket present petitioner was found selling suspected ganja in his grocery shop. Accordingly, a team of police went to the shop of the petitioner and recovered what is the total amount? 3.285 kgs of ganja. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 46 days, and considering the period of detention, he may be allowed to go on bail, as his further custodial interrogation might not be necessary. On the other hand, learned additional public prosecutor submits that prays for some more time for production of the case diary. I have considered the submissions made by learned counsel for both sides. In this case, the quantity of ganja recovered is 3.285 kgs, whereas the petitioner has been detained behind the bars for last 46 days, which in the considered opinion of this court is sufficient for making substantial progress in the investigation. Further, if the petitioner continues to cooperate in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation in Bongaigaon PS case number 20. Bongaigaon PS case number. What is the PS case number? 205/2024. 2025. Accordingly, in view of above, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the Learned Special Judge Bongaigaon with following conditions. Number 1 and number 2.
Item 44. Diplomats.
This bail application is accordingly disposed. First. Yes, item number? Yes,
Just above small quantity lordship, 2.69 kg of ganja.
case diary is there.
No. Serious company.
2.69 and commercial quantity lordship above 1 kg to 20 kg. Just above.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Bijoy Singh, who has been detained behind the bars since 24/8/2025, within bracket for last 32 days in connection with Bongaigaon PS case number 220/2025 under section 20B2B of NDPS Act. The learned counsel for the petitioner has submitted that the accusation accusation against the petitioner is of possessing how much?
2.69.
2.69 kgs of suspected ganja. Stop. He submits that considering the quantity of contraband seized from the petitioner, as well as period of detention undergone by him, he may be allowed to go on bail he may be allowed to go on bail. He further submits that petitioner is ready to cooperate in the investigation. Learned additional public prosecutor, on the other hand, prays for another date for production of the case diary. Stop. I have heard the submissions made by learned counsel for both sides. Why case diary could not be produced?
So they have given a communication asking some time, lordship.
No. Though the prosecution side has failed to produce the case diary today, however, considering the fact that in this case, petitioner has already been detained behind the bars for last 32 days, as well as considering the quantity of contraband seized in this case, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial interrogation may not be necessary. Hence, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Bongaigaon with following conditions. Number 1 and number 2. This bail application is accordingly disposed.
45. Here also CD has been received.
Wait, please, your lordship. Security is behind the bar for last 32 days for 5.23 grams of heroin was recovered. 5.23 grams.
Oh. Yes. What is this?
Here, lordship, what has happened, lordship, this present accused lordship, he has been involved in NDPS matters and 2 cases are presently pending against him. And from his locality lordship, all the other local persons lordship, they apprehended him and subsequently he was sent to police lordship. And
So-
he is dealing habitual offender in drugs lordship. So at this stage, it may not be allowed lordship. Because leniency. in terms of-
But in this case,
Lordship.
the investigation has progressed
Yes, it has progressed lordship.
and submissions which you are making
Yes.
would amount to punitive detention.
No, Lordship, it won't, Lordship, because the Supreme Court has also said, Lordship, that court cannot be lenient in NDPS matter, Lordship.
But quantity is very less.
Quantity is Lordship, intermediate quantity, Lordship, and considering the fact that he is a habitual offender, Lordship, 2 cases of same NDPS cases are pending against him, Lordship. So no leniency should be shown, Lordship, in my respectful.
He is not a drug peddler, Lordship. He is a drug addict.
And Lordship,
We have mentioned our grounds for.
they are
He is a drug
independent
addict,
witnesses.
Lordship.
Lordship will kindly peruse the FIR or the forwarding. The local people, Lordship, of the village have apprehended him, and he was handed over to police, Lordship.
He needs rehabilitation, Lordship.
Heard
We are
Mr.
ready
A-
for that purpose.
Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNFS has been filed by the petitioner Habzur Rahman, who has been detained behind the bars since 25/8 to 2025, within bracket for last 23 days.
32 days.
For last 32 days in connection with Morigaon PS case number.
Moirabari PS.
Sorry, Moirabari PS case number 135/2025 under section 21 within bracket small b/25 of the NDPS Act. The gist of accusation in this case is that on
24/8.
on where is the FIR? On
FIR is-
24/8/2025. One,
Contents is at page 14, Lordship.
one. Jaya Pegu had Kumar, SI of police, had lodged an affair before the officer in charge of Mikir Bheta police station, inter India, alleging that on that day an information was received.
That should be, Lordship, that was mistake practically. Case was registered at Moirabari and it is in the Moirabari, Lordship. That reading was Mikirbeta. But the case was at page 16, Lordship. Case was registered by Moirabari PS, OC Moirabari.
Moirabari police station. Inter alia alleging that the local persons local people have apprehended one peddler with how much? 5.23 grams of suspected heroin from his possession. Learned counsel for the petitioner has submitted that the petitioner is not a peddler, but a drug addict, and he needs rehabilitation. He further submits that considering the quantity of contraband seized in this case and period of detention already undergone by the petitioner, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that the petitioner is a habitual offender and there are other cases pending against him under NDPS Act. He also submits that there are observation of the apex court to the effect that in NDPS cases, in offense involving NDPS cases where the accused is shown to have been an habitual offender, the court should not be lenient while granting bail. Stop. I have considered the submissions made by learned counsel for both sides and have perused the case diary of Moirabari PS case number 135/2025. So the petitioner has stated in his petition that he is a drug addict. Stop. If that be so, he needs rehabilitation. Moreover, on perusal of the case diary, it appears that the investigation has progressed. FSL report has been received. Investigation has progressed fairly well, and it is pending mainly for the receipt of the forensic laboratory report. So, considering all these aspects, this court is, as well as considering the quantity of contraband seized and the period of detention already undergone, this court is of considered opinion that further custodial detention of the petitioner may not be necessary for fair investigation of Moirabari PS case number 135/2025. For the reasons mentioned aforesaid, the petitioner, above named petitioner, is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Morigam, with following conditions: 1 and 2. Send back the case.
6. So if CD has not been received.
What is the matter?
My lord, in between, my lord, and 53 days behind the bar, my lord. And quantity, my lord, 8.56, my lord.
564 kg ganja.
Ganja. Still it is intermediate quantity. Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Makibul Khan, who has been detained behind the bars since 3/8/2025, within bracket, for last, how many days?
53 days, my lord.
For last 53 days in connection with Patasar Kusi PS case number 155/2025 under section 20 B2C, B2B of NDPS Act 1985. The gist of accusation is that on where is the FIR?
Yes, 16, my lord.
On 2/8/2025, one Vikas Jyoti Deka, SIF police had lodged an FIR before the officer in charge of Patasar Kusi police station, inter alia, alleging that an information was received through reliable sources on 2/8/2025 to the effect that 3 persons would be carrying some suspected narcotic substance in a vehicle bearing registration number AS01SC 3376. Accordingly,
I'm sorry for interrupting. So in the forwarding, I have found, Lordship, that maybe 27A of NDPS may have been incorporated. So if Lordship just kindly allows me to take instruction.
27A is there.
It may be there, Lordship. The reference is there, Lordship. He is also liable under 27A. So whether it has been incorporated or not, Lordship, that instruction I may kindly be allowed to take, Lordship.
How much time will you require?
And now only, Lordship. Just after a few minutes.
Okay.
I'll just talk to the IO and.
Let me dictate the order.
Yes.
Accordingly, a police team was constituted and a search operation, a Naka checking was conducted. During Naka checking, the aforementioned vehicle was intercepted and the present petitioner was apprehended therefrom. During search of the vehicle, 8.564 kgs. How much ganja?
8.564.
kgs of ganja was recovered from the present petitioner. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 53 days, and considering the quantity of contraband seized in this case, his further custodial interrogation might not be necessary. Hence, he prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has submitted that case diary is not there. No? Submitted that some more time may be granted for production of the case diary. Let him come. We will dictate the remaining part. Episode dictate for him. Next item.
Item 47. Sorry, my
All of Jagai.
CD not received. And notice also.
Lordship, the petitioner is behind the bar since last 35 days, Lordship.
POCSO case.
POCSO.
The last occasion it was observed that POCSO is not attracted in this case, Lordship.
Why?
Actually, the FIR is at page 18, Lordship. Lordship, can you see the FIR? There was just a fight between both the parties in the marketplace. Quarrel was there. And just to make out a case of POCSO, then the daughter of the opposite party lost this FIR, Lordship.
Where is the
FIR is at
vernacular?
15, Lordship.
Vernacular.
20, page 20.
Vernacular 20.
Read the vernacular part. Read it.
I am reading. Binto Nivedan is a Mosh Kimoti Onamika da Peter Swenso, Hang Zurabat, Duck Swenso, Bahinda, Mohodor, Getter Kuribo, Bisharude, Zoakali, Rati Price Saranaman Bozat, Amsing Zurabato, Nibaki Sri, Lure, Peter Swenso, Badu Namor, Lora Azone, Moor, Horror, Nisha Hoi, Kazia Pesal Kuribula Dore. আৰু আমি লৰাজনক যাবলৈ কোৱা সত্ত্বেও নগৈ খং কৰি মোৰ দেউতাৰ লগত মোক প্ৰহাৰ কৰে লগতে থানা এজাহাৰ নিদিবলৈ ধমকি দিয়ে থানাত এজাহাৰ নিদিবলৈ ধমকি দিয়ে গতিকে মহোদয় গুৰুত্বটো সহায় কৰি লৈ
POCSO is not a accused.
Lordship, cross FIR also, the petitioner has lost FIR. That is at page 11, Lordship. Vernacular is at page 13, Lordship.
But Prohar Kore, but regarding the whether some injuries there are, we have mentioned as urgent, but it is not.
No, but it is not. Where is your forwarding any?
Forwarding at page 22.
Forwarding as page 22, Lordship.
Where is the accusation that he disrobed her and torn her clothes?
Ground of arrest number 2 during investigation, the accused person has torn the clothes of the complainant, come victim girl during the quarrel and tried to molest.
No. From where?
Oh yes, Malat, that.
Okay, interim.
Anamika Das, Malat, that informant is a girl, madam.
Actually, quarrel was between the father and this.
Informant is a girl, Anamika Das.
The daughter have lost their FIR, Lordship.
Heard. Miss, what is her name?
Yeah.
Heard Miss S.E. Ahmed learned counsel for the petitioner also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for production of the case diary. Stop. However, learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 35 days and no ingredients of any offense under POCSO Act has been made out on bare perusal of the FIR. She submits that the accusation made in the FIR is only limited to the physical assault, alleged physical assault made by the petitioner on the informed father of the informant. Informant is Gopal Sonar.
No, no, Anamika Das.
Anamika Das, okay. Gopal
Page-
Sonar also have lost an FIR. Very different one.
Page number malak 20.
20.
Vernacular malak. Vernacular malak. Apna dusra hai Anamika Das.
On the informant. She submits that no accusation as regards any thing which constitute an offense under POCSO Act has been made out in the FIR. However, the police, while forwarding the petitioner to the judicial magistrate, forwarding the petitioner before the Court of Learned Special Judge POCSO Kamrup Metro after his arrest, has stated that has wrongly stated that the petitioner had disrobed the clothes of the informant. She submits that there is no basis for such accusation. Stop. It appears that the notice issued to
This was not issued.
now it appears that the accusation made against the petitioner in the FIR does not constitute any offense under section 10 or 12 of the POCSO Act 2012. However, since the case has been registered under POCSO Act, let the notice be issued to respondent number 2. Let the petitioner shall take steps for issuance of notice upon the respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 2 days from the date of this order, returnable on 20 long date, 4th of November.
It is already 35 days now.
No, 4th of November. Stop. Let also a reminder be issued for production of case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner and also considering the fact that on bare perusal of the FIR, no ingredients of offense under POCSO Act has been alleged therein, the petitioner is allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge POCSO, Kamrup Metro and Guwahati, till arrival of the case diary, subject to following conditions. Number 1 and number 2, investigation condition, list as directed on
14.
on
4th
4th of November.
Wait, please, Lord. My city was called for my
CDD.
FIR lots will find page 14 mile. The petitioner is inside jail mile since 26/8 mile 2025. Today 30 days has already been completed.
What is the offense?
Offense mile, the allegation is that the petitioner has misused one government scheme mile by spreading the news in the village mile. That is the main
Misuse government scheme by?
the Janani Suraksha scheme.
How you have misused?
Well, it has been alleged that she spread the news of that scheme, and the person who will eligible for under the scheme, they will get some money. It is also alleged that the petitioner has take some money from the person and the beneficiaries.
Where is the FIR?
Base 14.
Scheme is Janani Suraksha Yojana. Pregnant women will get 2100 rupees from the government. Now, she convince village women and all this to submit the application, and when they get not all pregnant women out of more than 200 47 were found fake. Widow women, school going girl, and aged women also applied, and as she asked, and they get 2100 in their bank account. Subsequently, petitioner took 1800 from that, and only those women only got 300 rupees. But till now 47 now this type of cases come, and one some victims one lady Mamoni Devi 75 years widow. She also gave a statement that I got 2100, but subsequently only given to me 300. Other amount 1800 were taken back by the.
What is the progress of the investigation?
Investigation in the area total they have collected the schemes and statement of the official of the NRS and all this also.
30 lady my only problem, my son suffering from heart problem. And if father is a government person official he is out of the home that is why
Heard Mr. P.J. Soikia, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Trishna Devi, who has been detained behind the bars since 26/8/2025 under section in connection with Mikir Bheta PS case number 107/2025 under section 316 within bracket 2/318 within bracket 4/319 within bracket 2 of BMS. The gist of accusation in this case is that on 19/8/2025, Munmi Devi had lodged an affair before the Deputy Commissioner Morigao. Lodged an complaint before the Deputy Commissioner Morigao, which was treated as an affair in this case, inter alia, alleging that the petitioner has cheated innocent villagers by giving them false information regarding government schemes and had made ineligible persons to apply for Janani Suraksha Yojana, which is only meant for pregnant mothers or pregnant women for safe delivery. It is alleged in the affair that that out of rupees 2,100 given as assistance to pregnant women under the aforesaid scheme, the petitioner used to take an amount of rupees 1,800, leaving only 300 in the account of the actual informant. Stop. Learned counsel for the petitioner has submitted that petitioner is mainly seeking bail on the ground that she has been detained behind the bars for last 30 days and she is a mother of an ailing child who is suffering from heart ailment,
serious
heart problem.
medical documents and
Stop. On the other hand, learned additional public prosecutor has
one more submission. Co-accused has one of the co-accused has been released by the trial.
Stop. A client petitioner or counsel. Learned counsel for the petitioner also submits that one of the co-accused has also been released on bail. On the other hand, learned additional public prosecutor has submitted that there are sufficient materials in the case diary indicating to the fact that the present petitioner duped innocent women / girls who are not eligible to get any financial assistance under Janani Suraksha Yojana, and thereafter when the money was sanctioned to such applicants, she took back 1,800 rupees 1,800 out of rupees 2,100 sanctioned to such ladies. Stop. He further submits that till now the investigating officer has been able to identify 47 such candidates where fake applications were made to get financial assistance under Janani Suraksha Yojana. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Stop. Though there are sufficient incriminating materials against the petitioner in the case diary, however, considering the fact that the petitioner, how old your child is?
6 years, my
Petitioner is a mother of a 6 years old ailing child, as well as the fact that she has already been detained behind the bars for last 30 days, and also considering the progress made in investigation, this court is of opinion that if the petitioner cooperates in the investigation, her further custodial detention may not be necessary for fair completion of the investigation of the aforesaid case. In view of the above named petitioner is allowed to be released on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Morigaon, with following conditions, number 1 and 2. Send back the case diary.
49.
Service has not been completed. Office. Service support respondent number 2 has not been completed.
Okay, heard Ms. J. Ghosh, learned counsel for the petitioner. Case diary is there. Also heard Mr. K.K. Parashar, an additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served. Stop. However, as none has appeared for the respondent number 2, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, anybody, any amicus present in the court? Accordingly, what is the case? Your case?
Case is under section 87 and section 8 of POCSO.
Okay, let the amicus appear.
AB lawsuit.
This court appoints the Tapan Ranjan Deori learned counsel as amicus curiae to defend the cause of the respondent number 2 in this case. The petitioner is directed to furnish copies of bail application along with annexure to the newly appointed amicus curiae within 2 days from the date of this order. Let this case be listed again on reopening on 15th October. Let the case diary which is available be retained till that date. List accordingly.
Is a PRS a bail application not for the second time? Earlier it was rejected, Lordship. Now, Lordship, the investigation meanwhile has sufficiently progressed, and one of the co-accused has been enlarged on bail. That Lordship will find it page 17, Lord. He has been granted bail by the learned Court of Additional Session Judge, page 17, Lordship.
Is there?
Page 17.
Yes, what is the submission?
My submission, Lordship, that at the instance of the person who is alleged to have received injury, some cash amount was recovered from that person. That is one Hibjur Rahman, and that finds mentioned in the order passed by this honorable court on 25/7/2025 at pair number 6 of the order, that at the instance of one Hibjur Rahman, 1,89,000 was recovered. And as far as this present petitioner is concerned, he was the one who informed the owner in whose house the theft had taken place regarding the commission of the offense. And it was suspected that the informant suspected that he is the person involved in this offense.
Who is Hibjur Rahman?
No, Hibjur Rahman, as per allegation in the FIR, Hibjur Rahman.
No, why your prayer was rejected earlier?
After going through the case diary. That is not the true fact. This petitioner is the manager of one person, he manager of a one person, he has informant. Yes, manager of the informant. And that Hibjur is only the caretaker of the home. He do the household work. Now, this Mufazil petitioner convinced Hibjur that today he himself took 10 lakh rupees, that I'll loot this 10 lakh rupees, and I make hue and cry, and before that I'll tie up you. And he made the whole plan. He gave out of that rupees more than 10 lakh. Out of that amount, he gave 1,89,000 something to that Hibjur. First, you took this amount. Subsequently, that amount was kept in a relative's house, along with the Hifzur and Mofazul, they both went to the house of that lady Malat, keep that amount which is given to Hifzur, 1,89,000. And subsequently at night, he came, tied him, and broken the almirah and all this, punctured the vehicle.
Who? Present petitioner.
Punctured the vehicle.
It has come from the statement of which
Statement,
person?
statement of the Hifzur. And that lady also, that lady.
He is also an accomplice.
Accomplice, yes, Malad.
Whether he has been arrested.
No, Malad. Subsequently, and Hifzur was asked, don't tell anything to the owner, informant. Subsequently, when Malad informant came, he told everything. That person that yes, he forcefully given me. Firstly, he refused to take this money, but he threatened to kill, and because of that, Malad, I have মোক ভাবুকি দিয়ে উপায় নোহোৱাত মই তেওঁ কোৱা ধৰণে কৰিবলৈ বাধ্য হওঁ. So all have been planned by that. Subsequently, when tied up and all this, taken the money, and that then he made hue and cry. Subsequently, the neighboring people come. Malad elaborately Malad given. Subsequently, when the Malad
Okay.
and he became unconscious.
These facts were there before the court earlier also. Now, what is the new ground? New ground is release of the co-accused. That cannot be ended.
The stage of investigation.
That cannot. That.
And let them also clarify from the case diary if they.
That amount Malad more than 10 lakhs not yet recovered, because he is the main person, Malad.
This has happened. My responsible submission is that the entire thing with the additional public prosecutor has narrated. This has happened at the instance of the informant. And let them also clarify from the case diary whether the person against whom, the person who has made this revelation against the present petitioner, whether he has been.
What is your name, Mukhaz?
Because he is also an accomplice in this case.
Hifzur was not arrested. His statement is there, Malad. His statement is there. He was not arrested.
What
And
new ground?
New ground is the stage of investigation, which I have said that the investigation has sufficiently progressed, and that order of the learned additional session will be lodged.
Total 12,56,000 he took away, taken away, Malad. This present petition, 12,56,000 from the city.
Heard Mr. A. Ganguly,
Statement of the informant.
Other independent witnesses are.
learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This is for the second time. The petition. What is your name, petitioner's name?
Mufazul Islam.
This is for the second time. The petitioner, Mufazzul Islam, is approaching this court seeking bail in praying for anticipatory bail. Stop. His earlier prayer was rejected by this court, on 25/7/2025 in AB case number 1246/2025. After perusal of the case diary and after finding sufficient incriminating material against him in the case diary. The gist of accusation is quote para 3 from page 15. Para 4 from page 15. Learned counsel for the petitioner has submitted that the petitioner has approached this court for the second time, mainly on the ground that after rejection of the earlier bail application, anticipatory bail application filed by the petitioner, 2 months have lapsed, and therefore, the investigation might have been progressed. and custodial detention of the petitioner may not be necessary. He also submits that in the meanwhile, one of the co-accused, namely Hibsur,
No. That is on page 17, Atikur Rahman
one of the co-accused, namely Atikur Rahman,
Kodadi.
has already been granted bail.
21/7/20.
Bail by the Court of London, additional session judge. Stop. On the other hand, London additional public prosecutor has produced the case diary and has opposed the grant of anticipatory bail to the petitioner on the ground that no new grounds has been shown by the petitioner for approaching this court for the second time. He further submits that the present petitioner is the main accused on whose behest entire drama of looting of 11,56,000 rupees, 11,53,000 was staged. He submits that it is the present petitioner who took the amount and out of the looted amount, he paid rupees 1,89,000 to the co-accused Hibsur Ali. Hibsur has been arrested.
Hibsur's statement is that he was not arrested because he subsequently narrated the whole to the he was hospitalized. He was torture also. He was hospitalized.
Hibsur Ali alias
Subsequently,
I have considered the submissions made by London counsel for both the sides and have perused the case diary. On perusal of the case diary, it appears that still there are sufficient incriminating materials against the petitioner. And how much amount is still to be recovered? And around 10 lakhs and around rupees 10 lakhs are yet out of the looted amount is yet to be recovered. Stop. This court, I have considered this. This court is of on perusal of the case diary, it appears that on perusal of the bail application, second bail application filed by the petitioner, it appears that no fresh ground for approaching this court has been made out by the petitioner when his earlier bail application was rejected after perusal of after finding sufficient incriminating material against him in the case diary. Stop. As the incriminating materials available in the case diary are still there. Stop. Mere fact that sufficient 2 months time, sufficient time has been lapsed after rejection of the earlier anticipatory bail application may not in itself be considered as a new ground to entitle the petitioner to get the benefit of a favorable order under section 482 of BNSS. The prayer for anticipatory bail is therefore rejected. Send back the case. এই যে আধা মারিছিলে অলপ 2 মিনিট yes mandate then CD would be required.
27A, my lord, page 26, lordship kindly see. Page 26. 27A against my lord, second accused my lord, who fled away from the my lord spot. He was subsequently arrested, and against him my lord 27 has been added, my lord, page 26. Ground number 3 and 4, my lord. I am a driver. My vehicle was hired by this person, my
Page
lord.
number 20.
26, my lord.
Yes, where?
My lord, 3 and 4, my lord. Financing and harboring, my lord. Financing and harboring, my lord. So this is, my lord, individual activities, man.
No, if
I am the driver.
no, one by one. Name of the present petitioner is?
Mokibu, my lord.
Whether 27A has been added. Okay, key as the last line. On the other hand, an additional public prosecutor has prayed for some more time for production of the case diary. He has further submitted that he has been telephonically informed by the investigating officer of this case, by the officer in charge of the concerned police station, that in this case, section 27A of the NDPS Act has been added. And therefore, he submits that embargo of section 37 of the NDPS Act would be applicable. Stop. Considering the submissions made by London additional public prosecutor regarding addition of section 27A of the NDPS to this case, which brings in the restriction embargo of the section 37 of the NDPS Act, comma. This court is of considered opinion that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, issue reminder for case diary. Let this matter be listed. Date 23rd October. ওপৰৰ যিটো আছিলে submissions, ইমান নালাগে। Only that he has been detained behind the bars for last 53 days. ইমানতে ৰখাই দিব। বাকি gist of accusation নালাগে। 23rd of October.
51.
PH will appreciate my lord. My lord, FIR is in page, my lord, 10, my lord.
Notice, my lord, in this case issued only on office note, my lord, shows, my lord, 19/9/25. My lord, motion it was listed on 16/9, subsequently second and notice it was only 19/9, my lord. Service not complete, my lord.
What is the offense?
Well, section 6 of the POCSO. But my lord, lordship may kindly see page number 14, my lord. Thus, I'm referring to the age of the victim, my lord. Here, the date of birth is shown to be 23/3/2007. FIR was lodged in the month of June, when she was already 18 years. Her case is that, my lord, she was raped by the petitioner in the month of February, and FIR has been lodged in the month of June, my lord.
Just become 5 months pregnant because of that subsequently, my lord.
And my lord, I have come to know that she has already given birth, my lord. And I have already.
Yes, there is there.
It is there, but Amicus may be, I am not, my lord, subsequently, my lord, we have to wait, my lord, service report or Amicus may be appointed otherwise. I have.
Materials are there on.
Materials are there, my lord. See, he is a 55, 60 years old man.
Okay, then we are appointing one amicus curiae. Heard Mr. M.J. Chaudhary, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. The office note dated 19/9/2025 shows that the steps for issuance of notice on respondent number 2 was taken on that day. However, till date, no service report has been received. Since when you are behind the bars?
No, my lord,
anticipatory.
Okay. Considering the nature of this case, this court intends to appoint one amicus curiae to represent the cause of the respondent number 2 in this case. Accordingly, total list of amicus curiae. Accordingly, Mr. Surajit Das, whose name appears in the list of amicus curiae, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner shall take steps, shall furnish a copy of bail application along with the annexures to the newly appointed amicus curiae. And within 2 days from the date of this order, the case diary which is available may be retained till next date.
Because my lord, they have the habit of the lodging false case, my lord. My lord, we have annexed the annexer 3, my lord.
No,
Our elder brother, elder sister also did the same thing, my lord.
It is anticipatory bail only.
This is only some interim protection because he is ready to go for DNA test also, my lord. I said this child is not mine. I'm a diabetic patient, my lord. I have also annexed all the documents, my lord. And when she was already 18 years, then she lost the FIR, my lord. Totally making case. Her elder sister also did the same thing. And person was acquitted, my lord. We have annexed the annexer 3, my lord.
Let us hear the other side also.
Some entire protection only till then, my lord.
No, not at this time. Let this case be listed on 15th of October.
It was CD, my lord.
Is there is there,
Yes, my lord. Yes, there is receipt, my lord.
you are on interim bail.
Yes, my lord. He was on interim, my lord, on 3/9/9.
He has cooperated.
My lord, was pleased to grant interim and he accordingly appeared, my lord, 6/9/25. Otherwise, my lord, implications are there.
Heard Mr. G. Pathak, learned counsel for the petitioner. Also heard Mr. K. Basha, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner, namely Hirok Jyoti Hazarika, was granted interim bail, interim anticipatory bail by this court on 3/9/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Sonapur PS case number 130/2025 and has submitted that the petitioner has appeared before the investigating officer and his statement has also been recorded under section 180 of BNSS. Stop considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation. The interim bail granted to him by order dated 3/9/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. This bail application is accordingly disposed of. Send back the case.
Please, Lord.
Yes.
My lord, appeal is already admitted, my lord. I am for IA criminal, my lord. Because sentence is only, my lord, 3 years. But appellant failed to pray for bail when the sentence was pronounced in the trial court. So, my lord.
You are behind the bars. You are in jail now.
Yes, my lord. I am paying for releasing during pendency, my lord.
Yes,
Already
Mr. Bosho.
already 222 days.
3 years.
3 years.
Heard Mr. K.U. Ahmed, learned counsel for the applicant. Also heard Mr. K. Bosho, learned additional public prosecutor. Ayekon, additional public prosecutor. This application. POCSO is there.
My lord, on that regard, my lord, notice was issued on the very first day, my lord.
But service,
POCSO matter, my lord. In this case, my lord.
it has to be
Yes,
heard.
my lord, that is to be heard, my lord.
We could maybe.
That maybe we will take care, but you have to make it a mention that is a POCSO matter. That is a different thing.
It appears that in this case,
Notice already issued, my lord.
in this case, service report in respect of notices issued to respondent number 2 has not yet been received. The learned additional public prosecutor is therefore requested to take information regarding service of notice on the respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the fate of the notice on the next date fixed.
Right.
Let this case be listed on 22nd
Right.
October.
But 13 may be possible, madam.
13.
1-3, madam. Reopening the madam. But, my lord,
15th. 13 may not be possible.
then, my lord,
Products of the item 1.
22nd.
27.
Production is. Yes.
Lordship, other day, my Lord Learned PP submitted that the charge sheet has been filed. My Lord, in the open court order dictated. The instance thing happened that when I get the bail order, my Lord, and the order is not mine, my Lord. Thereafter, my Lord, stenographer took me to my Lord Justice Sharma, and Lordship said that on the next date we will clarify all this. This is the.
No, I have not understood what.
Other day, my Lord, on 16, my Lord, PP submitted that charge sheet has been laid before the court.
Okay.
And accordingly, it was disposed of. But when we get the certified copy,
Which was disposed of?
this
The present case was
Present
disposed
case.
of, Lordship, as it was charge sheeted, but inadvertently, Lordship, there was.
Oh, it was
Yes.
dictated that it is
Yes.
disposed of,
Yes.
but in the order sheet.
Yes. Yes.
Okay.
So that may be clear. So the charge sheet may be recorded and the matter may be disposed of.
Now, today we will dispose it of.
Yes.
Heard Mr.
ML.
M. Ali, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the learned additional public prosecutor has submitted that in this case, charge sheet has been filed bearing charge sheet number.
42/25 dated 29/8/25.
Stop. In view of the submission of charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
In the event of filing, that may be considered.
No, it should not be considered. It should be rejected. Oh,
My Lord,
that submission you
on
should make before the
on
trial
merit, I
court.
have case, my Lord, that's why.
So you persuade the trial court.
Always.
Made please, Lord.
Yes.
482 application, Lord. Before taking to the FIR, Lord, there is a background of in this case, Lord. But the petitioners herein are all family members. The petitioner number 1, Lord, he is a ward member. He's been recently elected. He was earlier also a ward member, Lord. Lord, on earlier occasion, Lord, if your lordships kindly come to page 24. Page 24, my Lord, he has lodged an FIR, my Lord, earlier. Against, my Lord,
Who
Nizamuddin,
lost the affair?
the petitioner number 1 hearing, Jamaluddin.
Okay.
Page 24, if your lordship please.
Yes.
So the accused are Nizamuddin and his family members, Lords. Not there was an, if I can read, Lords, with due respect, I would like to inform you that today, 13/11/2000 at around 12 p.m.
Now, what was the gist? You can
The
tell.
gist is, Lords, the family members has not hit one auto driver Sihabuddin, and when Lord, one of the brothers of the petitioner number 1 went to intervene, Lord, he was also hit. Lord, thereafter, Lord, he was taken to Lord, hospital. Case was registered, Lord. That is, if your lordship sees page 25, it's Karimganj PS case number 870 of 23. Now, my lord, thereafter, my lord, again a complaint was lodged by the informant, which your lordships find at page 28 before the ADC. My lord, alleging that, my lord, there is a threat by the family members of the informant, my lord, for lodging false case because of he's filing the earlier case, my lords. And there was a pressure created upon him to withdraw his case, which he did not do, my lord. And there has been constant threat, because of which, my lord, he has to file this petition before the ADC. Subsequent, my lord,
Who are you?
my lord, I am the petitioner number 1.
Namely, Jamal.
Jamaluddin.
Yeah.
My lord, the local public of the area at page 33, my lord, led by the petitioner number 1, also has lodged a complaint on 13/3/2024 against the misdeeds of the informants. And there are as many as 184 persons, my lords.
What complaint?
My lord, that the atmosphere of the village has been tarnished, my lord, because of the illegal activities. And at page 48, my lord, the SP has forwarded this complaint to the officer in charge police station, my lord, at page 48. Now, all these, my lords, apprehensions came to reality, my lord, when this FIR was filed at page 13.
Page?
13, my lord. Next one.
Yes. What is the accusation?
My lord, that there is a criminal trespass, my lord, threatening has been made, earrings and mobile phone has been stolen. And including for 12 persons, my lord, 8:30 in the morning. And the only allegation or known bailable is theft, my lord.
Who is the informant?
Informant
Wife
is
of the.
Sahida Begum, wife of Nizamuddin.
Now your submission is that this is a false FIR.
Yes.
Apart from that,
Lord, there is no nothing as such that they are not at all involved. Lord, even reading of the FIR also, there is an initially a statement has been made as regard accused number 5 and 9. And reference is only, Lord, how could so many people come all along, Lord, in the same place, same day, when the persons, they know that what kind of people they are dealing with, Lord. There is a trial going on as regard the earlier case, Lord. And two of the accused has also been arrested earlier, my lord, and they were released on bail. And my lord,
out of these accused persons?
Yes, not out of this. Two other accused, out of the accused persons, my lord, who are not petitioners herein.
Named in the FIR?
Yes, yes. 12 have been named, my lord. 2 has been arrested, and 10 are before your lordships.
Okay, after arrest, they were released on bail.
Yes, yes. That order I have annexed, page 11, page 49, order dated 11/9. That's out and out an abuse of process of law, my lord.
On what ground the bail was?
For failure to produce the case data.
Because they were in custody, my lord, and the main allegations is regarding theft, and theft is of one earring, pair of earrings, and mobile phone, my lord. And for that, my lord, all these 12 people are involved.
Oh, no, bail was granted due to
Yes, because
failure of the
yes.
failure of the.
Court found it that they were in custody for sufficient. But I am on the allegation part of it. Your lordship has seen the background.
No, but without perusal of the case diary.
At least praying for the interim prayer, my lord. Your lordship has seen. My lord, wife is there. The brother's wife is also there. Small, my lord, college-going students are there, my lord. The informant has enmity, my lord, all along. Not once, not your lordship has seen. But had it been a normal FIR, my lord, I would have, my lord, make a submission
Yes,
to that
Mr.
regard.
Here, Lordship, the grievous hurt section is there, and also Lordship, outsizing the modesty of a woman, that section is also there, Lordship.
That has not been affected in that.
No, the sections are here. And there, from the schedule of the FIR, Lordship will kindly see that clothes were torn and they were beaten, Lordship, with stick. And all those things are there.
Now this FIR is of
Yes.
25/7.
Yes, ma'am.
Why you are approaching this court so late?
Petitioners have been harassed, my lords. Police is coming every day. That's why, my lord, we are coming.
When police came?
Lord, even 3 days back also they came. They are not at their home, my lord. Lord, your lordship would see the background. Lord, the trial is going on against the informant, my lord.
Trial in which case?
But PS case 3, my lord, that was lodged by the petitioner hearing.
Charge sheet has been filed.
Yes, yes. Charges has been filed, my lord. And he has also been summoned as witness in that case, my lord.
Heard. Mr. B. Sharma, learned counsel for the petitioner.
R. Dubey for the.
Sorry. Mr. R. Dubey, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Jamaluddin, and write the name of all the petitioners from the Jamaluddin 2, 3, 4, 5, 6, 7, 8, 9, 10, who are apprehending their arrest in connection with Karimganj PS case number 348/2025 under section 74 with /117 within bracket 2 /169 within bracket 2 /269 /303 within bracket 2 /351 /329 within bracket 4 of BNS. The gist of accusation in this case is that on 25/7/2025, the one Shahida Begum had lodged an FIR before the officer in charge of Kaliganj WP Kaliganj was watch post under Sri Bhumi police station, under Karimganj police station, inter alia, alleging that the petitioners named in the FIR, including the accused persons named in the FIR, including the present petitioner, had on (24/7/2025) at about 8:30 AM threatened and abused the informant with foul language, and thereafter they entered into the house of the informant and tried to pull off the clothes of the informant and her daughter, and also assaulted them. It is also alleged in the FIR that when the informant and her daughter started screaming, the accused persons left the house of the informant. And while at the time of leaving the house, they took a pair of earrings and mobile phone therefrom. Learned counsel for the petitioners has who is on bail out of this 12?
Lord, out of this 12, Lord, 3 Abdul Jalil Nashiruddin, 3 and 6 at page 13, your lordship would see.
Learned counsel for the petitioner has submitted that petitioners has submitted that the aforesaid FIR has been lodged by the wife of Nizamuddin, by the informant who is the wife of one Nizamuddin, only to harass the present petitioner, as prior to filing of the said FIR, the petitioner number 1 had lodged an FIR against the husband of the informant, namely Nizamuddin, and his family members, including the informant Shahida Begum. And on the basis of the said FIR, charge sheet was also laid against the informant also.
Yes.
Against the informant and her family members. It is also submitted by learned counsel for the petitioners that during the pendency of the aforesaid case, the where have you
Page 26, my lord.
the petitioner number 1 had also approached the additional district magistrate Karimganj by filing an application under section 107 CRPC against the informant and her husband, inter alia alleging that the informant and her family member were threatening the petitioner to withdraw the case lodged by the petitioner number 1. He submits that in this respect, on 13/3/2024, a public memorandum was also filed by about 182 numbers of persons against the informant and her daughter, alleging therein that they are indulging in lodging false complaint and thereby vitiating the environment of the village. Learned counsel for the petitioner submits that in the meanwhile, 2 of the accused persons named in the FIR lodged against the petitioners, namely Abdul Jalil and Nasiruddin, have already been granted bail by the Court of Learned
Chief Judicial Magistrate.
Chief Judicial Magistrate Karimganj. Stop. He further submits that the incident which happened prior to lodging of the FIR by the informant Shahida Begum makes it clear that the instant FIR has been mainly filed only with a view to harass the petitioners. The learned counsel for the petitioner further submits that the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that since there is an accusation of attempt to outrage the modesty of the informant and her daughter, the case diary may be called for. Stop. Let the case diary be called for. Let this case be listed on 3rd of November. In the meanwhile, considering the facts which preceded the filing of the FIR by the informant Shahida Begum, as well as considering the fact that Shahida Begum, this court is inclined to grant interim protection to the petitioners during the period before arrival of the case diary. Hence, the above named petitioners are directed to appear before the investigating officer of Karimganj PS case number 348/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with Karimganj PS case number 348/2025, they shall be allowed to go on interim bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2, lists accordingly.
Criminal appeal, my lord, and a missed case is also there, my lord. Now he was convicted for 3 years under 354 IPC, my lord.
In appeal,
And missed case-
appeal we are admitting.
Yes, sir. And a missed case,
Heard
he may
miss,
be allowed to remain on previous bail, my lord. 3 years conviction.
heard Mr. A.M. Bora, learned senior counsel assisted by Mr. M.S. Hussain, learned counsel for the appellant. This appeal under section 415 of BNSS has been filed by the appellant Prashanto Das, impugning the judgment and order dated 27/8/2025, passed by the Court of Learned Additional Session Judge number 4 FTC Nagaon in sessions case number T within bracket T-2/233 within bracket N 2023, whereby the appellant was convicted under section 354 of the IPC and was sentenced to undergo simple imprisonment for 3 years and to pay a fine of rupees 3,000, and in default of payment of fine to undergo further simple imprisonment for 1 month. The petitioner was also convicted under section 354A within bracket 1 within bracket small Roman 1 of IPC and was sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 1,000, and in default of payment of fine to undergo simple imprisonment for 1 month. Stop. He was also convicted under section 354B IPC and was sentenced to pay a fine of rupees 5,000. And was sentenced to undergo simple imprisonment for 3 years and to pay a fine of rupees 5,000, and in default of payment of fine to undergo further simple imprisonment for 2 months. Let the records of the trial, this appeal is admitted for hearing. Let the records of the trial court be called for. Registry to take steps for requisitioning the trial court records. Let this case be listed after 4 weeks. In the interlocutory application, this interlocutory application has been filed by the applicant Prasanta Das. Under section 430 of BNSS, praying for suspension of the execution of sentence imposed on the applicant by the judgment and order dated 27/8/2025, passed by the learned additional session judge number 4 FTC Nagaon in sessions case number within bracket T2 2/23 within bracket N/2023. By the said judgment, the applicant has been from the main appeal, conviction and sentence. Learned counsel for the petitioner has learned senior counsel for the petitioner has submitted that since the applicant has also impugned the aforesaid judgment by preferring the connected criminal appeal number 376/2025. He submits that the said appeal has already been admitted for hearing and the applicant is hopeful of getting a favorable result in this said appeal. Now, he further submits that as in the aforesaid case, the applicant has been sentenced to undergo imprisonment for 3 years only, which is an imprisonment for a short-term period, unless the execution of sentence imposed on the appellant by the impugned judgment is stayed, his appeal may become infructuous. Stop. I have considered the submissions made by learned counsel for both sides. Stop. Since the appellant has been convicted for a short-term period of the appellant has been sentenced to an imprisonment for a short-term period of 3 years only. If the sentence is allowed to run concurrently during the pendency of the connected criminal appeal, there is a possibility of this connected criminal appeal becoming infructuous. And therefore, during the pendency of the connected criminal appeal number 376/2025, the execution of the sentence imposed on the petitioner by the impugned judgment is stayed during the pendency of the connected criminal appeal, subject to the condition that in the event of dismissal of the connected criminal appeal, the applicant shall surrender before the trial court to serve out the sentence imposed on him by the impugned judgment. You are on bail.
I'm on bail.
The petitioner is also allowed to remain on the previous bail granted by the trial court, subject to aforesaid condition. This interlocutory application is accordingly disposed of.
Obliged.